My lord, we are the added respondent. Last time on our application under Order 22 Rule 10, Your Honor was pleased to add us as the
Yes.
party respondent. Added respondent. My lord, initially this is a suit filed by the predecessor in the interest of the appellant. It's a suit for releasing of the mortgage deed, alleged that. That was, though the defendant out there, he sold the property. Soon after purchasing, he alleged that he purchased the property and he sold it. Sold it in favor of on Rohini Bandyopadhyay for valuable consideration. Thereafter, he sold the property. Father sold the property to one Kalidas Mondol, and amongst the arrangement of partitions between the brothers, one of the brother got the entire shares, and he thereafter his heirs subsequently sold the property in favor of Zulfikar, the added respondent. Now, due to interventions of the Arakushi's heirs in the suit property, while the added respondent was owning and possessing and cultivating the suit land, there's an interference. He was forced to file a suit, and he obtained an order of injunctions. And the Arakushis, they appeared before the suit, before the trial court, and for the first time they told that there is a pending proceeding that is before this honorable court, and subsequently we came and filed this.
Very.
From the record, we find that there is an order, an application being made by the appellants and for police help. That is still pending. It was not proceeded with.
No one is appearing on behalf of the appellant.
Yes, Lordship. We served with a copy of the applications. No one appeared.
Please take down. Added respondents are represented through learned counsel. Now. It appears that the instant appeal is running in the list for quite few days. Copy of CAN applications being CAN 7 of 2024 was served upon the appellant, but no one turned up. No accommodation, full stop. No accommodation is short for. Considering the same, the instant appeal B and the same is hereby dismissed for default. B and the same is hereby dismissed for default. Next, interim order, if any, passed by this court during the pendency of the appeal is hereby vacated. Next, trial court record, if received, be returned to the learned trial court forthwith. Next.
Obliged, Lordship.
Lordship, item number 2, Mr. Divanik Banerjee is appearing. Lordship, he's on his legs. I'm praying for a very short passover.
What is this matter?
Lordship, I'm not briefed in the matter. He just requested me to take a passover. He's on his legs.
Why it is appearing under the heading of 2 you mentioned?
Lordship, I'm not briefed in the matter, Lordship. I won't be able to.
Well, I'll pass it over.
Grateful, Lordship.
Modification. Not today.
Yes, my lord. This matter has come up as my instance. My client, my lord, they compromise out of settle the matter. My lord, this is a letter.
Who are you?
I am for the appellant. This is
You
a
are for
letter.
the appellant.
Yes. This is I have an advocate on record, my lord.
Are you the advocate on record for the appellant?
Yes, yes. Well, this is a letter kept on record and lower court record sent down. They settle out of court between the parties.
Please take down. Your full name, Miss Sheila Sarkar.
Yes, my lord. Yes, ma'am.
Miss Sheila Sarkar, learned advocate on record, appearing on behalf of appellant, submits that the dispute between the parties has been settled amicably outside the court. A full stop. In terms of said settlement, the appellant doesn't want to proceed with this matter further. Ms. Sarkar has submitted a written instruction of the appellant to the court. Peruse the written instruction. Whether Latifur Rahman is the sole appellant?
Yes, my lord. Muhammad Latifur Rahman.
Sole appellant, okay. Let the written instruction of the sole appellant be taken on record. Full stop. Having heard the learned counsel for the appellant, and considering the written instruction, let the second appeal be and the same is hereby dismissed as not pressed. Full stop. Next paragraph.
And lower court record sent down.
Interim order, if any, passed by this court during the pendency of the second appeal be hereby vacated. Full stop. Next paragraph. Trial court record, if received, comma, be sent down at once to the trial court.
By special messenger, cost put in by my client.
Through special messenger,
Within a week.
comma, cost to be borne by the appellant. Full stop. Appellant is directed to put the special messenger cost with the department within a week from that.
I'm grateful to your lordship.
SAT disposed of.
I'm deeply obliged.
My lord, I am appearing on behalf of the appellant pursuant to your. Yes, my lord, item number 5, I am appearing on behalf of the appellant pursuant to your lordship directions on 20th January 2025. I have paid the special messenger's cost for bringing the trial court record as per the direction, and I have also served notice upon the non-appearing respondents as per your direction, mentioning that the matter have been restored by the Honorable High Court, my lord. This is the
Just wait.
This is the affidavit of service, my lord.
In pursuance to the direction of this court dated January 20th, 2025, the appellant has put in the special messenger cost, in the department for bringing trial court record. Full stop. The appellant has also served upon the respondents regarding the restoration of the appeal. Full stop. Affidavit of service filed on behalf of the appellant is taken on record. Full stop. It appears that the appellant has complied the direction of this court dated January 20th, 2025. Considering the compliance, let the appeal be proceeded accordingly. Let the matter be go out of the list. Parties are at liberty to mention.
My lord,
Yes,
my only prayer, another direction may be given for bringing the trial court record, my lord.
already direction is there.
Obliged, my lord.
Next.
My lord, I'm for private respondent. My lord, I'm playing for short passover, my lord.
Which for the appellant?
I'm for the private respondent. ma'am.
You are for the respondent.
Yes, ma'am.
Give me the file.
I'm well, I'm the applicant and defendant in this.
Take your breath first.
Sorry, my lord.
Not to hurry.
My lord, I am applying for the
This is
applicant
item number
6, my lord.
item number 6. You are the appellant.
I am the defendant and respondent in this matter, my lord.
Okay, who is the appellant? You have been represented. Don't hurry. So, what are the applications pending?
My lord, my application is pending.
Your application is there.
My lord, my application is CAN 14. My application is CAN 14 of 2024, my lord. Now, my lord, what happened? If your lordship kindly sees the last order, 18/9/2023, that was the last order, my lord. Now, my lord, what happened? This appeal was dismissed for default, my lord.
Very well.
Now, my lord, Her Lordship Honorable Justice Dattopal directed the appellants to serve us a copy of the restoration application and the condonation of delay application, which are the CAN 12 and CAN 13. I do not have the copy, my lord, so I cannot indicate your lordship that which is for the restoration and which is for the condonation of delay. But I presume that since there are two applications, one must be of restoration, one must be of condonation of delay. Now, my lord, the earlier advocate who was appealing this matter, Justice Dattopal directed the learned advocate of the appellants to serve us a copy. No copy was served, my lord. Now, on 18/9/2024, my lord, the last order, a misrepresentation was made before this honorable court that since the earlier learned advocate was sick and since he could not appear, the learned advocate directed the learned advocate of the appellants to take adjournment in this matter. No such request was made, my lord. Now, my lord, after that, the Honorable Justice Dattopal was pleased to call for the records of the learned trial court, my lord. Now, my lord, a question that I put to myself: appeal which has been dismissed for default. The appeal is not there in the eye of law till now. The appeal has been dismissed for default. Now, my lord, the restoration applications are pending. How can a call for records order be made in such appeal, my lord? This is a question. For recalling of that order only, my lord, I filed my application called the CAN 14.
Mr. Devashish Shur and Gautam Malik.
My lord, that is, they are for the appellant, my lord.
They are for the appellant.
My lord, I am for the respondent, my lord. Mr. Bhavesh Chandra Bishwas was appearing in this matter, my lord. Now, my lord, he is seriously ill, my lord. So, my lord, she has been pleased to give a no objection, my lord. My junior is the advocate on record now, my lord. Now, my lord, there was no instruction from Mr. Bishwas on the last order that you take an adjournment in this matter because we do not have the copy of the application till now. Because we want to seriously oppose this restoration application, my lord. Because my lord will see 1990 appeal till date. 1990 appeal till date. The appellants have made no serious efforts to get the appeal heard. They have only intentionally made the appeal dismissed for default, and then they restores the appeal and they keeps the appeal pending just because there is an interim order in the appeal. And now, my lord, when we go for recording our name before the concerned BL and LRO, what do the appellants do? The appellants show that, see, since there is a restoration order and the appeal is lying before the honorable court, you cannot record your name. But we have won before the two forums of law. Now, my lord, we want the appeal to get heard but the appellants do not get the appeal to get heard. And that is the reason why, my lord, we seriously want to oppose the restoration application. But, my lord, in spite of pendency of the restoration application, a call for records order has been made, my lord. So, my lord, CAN 14 has been filed on that ground to recall that order because there is no appeal in the eye of law.
Have you served CAN 14?
CAN 14, my lord, I do not have that instruction, my lord.
You served then. You
Yes,
served.
my lord, I have served, my lord.
Have you served?
Yes, my lord. This is in paper. I have
File
served.
affidavit of service.
My lord, affidavit of service is not there, but there is a noting of the learned advocate. That is there, my lord.
Issue is the learned advocate appearing on behalf of the appellants has not taken the no objection from the earlier learned advocates of the.
For the appellants, my lord.
Yes.
Oh, my lord.
That is the defect which was
Well, Mr.
raised by the
Devashish has not-
department.
My lord, Mr. Devashish was appearing.
Yes.
Mr. Devashish has probably not taken the no objection.
Mr. Devashish has not taken the no objection from previous learned advocate, Mr. Amal Kumar Pramanik
বলেছি, sir.
and Dhan Krishna Adhikari.
My lord, we have served the copy, my lord. We have served the CAN 14 application, but they have not served
Upon
the CAN
whom?
12. Upon Mr. Devashish Sood itself, my lord.
Okay.
Because Mr. Devashish Sood was appearing, my lord. My lord, I may show the. No, I said, my lord.
Please take down. None appears on behalf of the appellant. Mr. Sachin Saj appears on behalf of the respondent.
Now,
CAN 14 of 2024 is an application for recalling an ex parte order passed by this court on 18th of
September.
2024 for recalling the trial court record. It appears that the department has put a note containing it earlier that learned advocate for the appellant, Mr. Devashish Sood, has filed a vakalatnama without taking no objection from previous learned advocates, namely Amal Kumar Pramanik and learned advocate Dhan Krishna Adhikari. I have perused the order passed by this court on 18th of September 2024. Full stop.
My lord,
The
53
instant appeal was dismissed for default by a order of this court dated 15th of March 2021. Thereafter, appellant filed two applications one for restoration, that is CAN 12.
12. I don't know, my lord. There are two applications, CAN 12 and 13. One may be for the restoration, one may be for the condonation of delay, my lord. That I do not know, my lord. There are 12
Application for being CAN 12 and CAN two applications. That is CAN 12 of 2013 and CAN 13 of 2013 for restoration.
CAN 12 2023, my lord.
2023.
12
12
and
and 13
13 of
2023. Both of 2023. For restoration as well as application under Section 5 of Limitation Act for condonation of delay, respectively. Both the applications are yet to be disposed of. In that situation and tenure, this court has passed an order on 18/9/2024. Stop next. On perusing the order, it appears that one accommodation is sought for on behalf of the respondent. However, the order was passed ex parte. Considering the fact and merit of this matter, merit of Can 14 of 2024, it appears to me that the trial court record is not required to be called for until and unless the second appeal be restored. Under the same observation, I think it necessary to pass an interim order so that the trial court record which was already called for, need not to place before this court.
Obligement.
Let the matter appear in the list. Let the matter along with the Can 14 of 2024 be appear in the list on March 7 under the same heading. Full stop. The department is directed to issue intimation upon the learned office of the learned TCR, learned trial court, to not place the LCR, not place the TCR till further order.
My lord, Can 12 and 13 may be served upon us, my lord.
They are not there. Okay. Respondent is further directed to serve the copy of the
But appellants of
no you.
But I am the
serve
respondent.
copy, yes, copy of the application being Can 14 of 2024 upon the parties,
Only appellant is there, my lord. The appellants,
upon the appellant,
upon the appellants, my lord.
upon the appellant personnel.
But appellant personally, my lord.
Person.
My lord. Obligement.
Next,
Lordship, at now 7 I am appearing on behalf of the appellant and 8 I am appearing on behalf of the respondent.
7 and 8.
7.
What are the applications pending?
My application, I filed the application, Lordship. Application under Order 22, Rule 10. During pendency of the appeal, appellant number 2, Naran
So
Chandra.
you are the appellant of respondent number item number 7.
7, SA number 478.
478.
Yes.
And respondent of SA number 310.
10.
And you are appearing on behalf of the respondent of item number 7. Item number 7, you are the respondent.
I am the applicant so far as SA 310 is concerned.
Yes. Very good.
My lord is called from me.
নামটা দিয়ে যাও
Obligement.
Yes, Lordship, during pendency of the appeal, appellant number
What
2.
is the can
Oh,
number?
In SA number 478, can number 2.
Can 2.
Lordship.
SA number 478, can number 2.
Lordship.
কাগজগুলো যা অবস্থা 478 can number 2. Do you have any cans?
I have no can, but yes, I can in other bad appeal also.
Same can, Lordship. Here, Lordship, appellant number 2 in the second matter in the respondent.
Okay, can 1 of 2025 in SA number 310.
Right.
Lordship.
And
Same can, same person.
what is the contention?
Contention is the appellant number 2, Naran Chandra Sahu, during pendency, all entire property transferred to his legal heirs. I annexing the document, deeds and as well as record. So name of the Naran Chandra Sahu may be explained and the subsequent purchaser name to be added.
Who are the persons?
The legal heirs.
The legal heirs.
Loss.
The name, where is the name?
Name already loss is stated in paragraph number 2 loss.
Paragraph number 2.
Loss.
By registered deed of gift.
Loss. And also it was recorded in the LR record of right.
Yes, so far my instruction goes. In Narayan Chandra's house, respondent number 2, the applicant number 2 also died long before.
Yes, I stated that already.
Died long before, but no death certificate has been annexed.
But before death, you already transferred this property.
You know, why during his lifetime the application was not made?
Loss appeal already dismissed. Appeal last talking on lossy was appeal was restored.
Narayan Chandra's house died long before.
There are 3 appellants. Manoranjan Sahu, Narayan Chandra Sahu and Gopal Chandra Sahu.
Right.
And you are Bodhanath Maji.
Final.
So your submission is that Narayan Chandra Sahu was expired
Long before.
long before. No, he transferred the by deed of gifts on 17th of
October 2023.
Thereafter he must have died.
Thereafter you must. Yes.
Thereafter he died.
Yes, loss.
But the application was not filed, substitution application like that.
Substitution application was filed, no death certificate has been annexed here. When he died, that has not been mentioned in the application. When Narayan Chandra's house died.
It was not mentioned in the application.
No. Date of death is not mentioned.
However, he lost his interest. He died maybe before his death. He transferred the
Inter share loss.
entire share, right, title, interest devolved upon the
So, during
transferring.
his lifetime, this application could be made.
Okay.
But after his death, there is delay of more than 1 year, 2 months. The delay.
No, this is not an application for substitution. This is not an application for substitution. This is application for recording the name of the transferees.
Yes, loss.
But that would have been done during the lifetime of the respondent number 2, Narayan Chandra Sahu.
Very well. Anything?
No, I do not know the death of Narayan Chandra Sahu. That is relevant for this application.
Whether his date of death is relevant?
No loss.
Relevant because
Date of loss. Yes.
or
Death
after-
certificate also in my loss.
Whatever may be, what is the reason? for-
Date of death loss 2nd February 2024.
This is not an application for substitution.
Yes, loss.
Prior to his death, he has
Loss.
disposed of all his interest
Interest loss.
in the suit property.
Also. And also that gift deed was accepted, recorded the name of
It is
the
all together separate issue.
loss.
4 persons.
Loss. Para 2, I given the particulars, name and particulars of the
Very well.
person.
So what is the status of the appeal?
Appeal already. Loss. LCR call for examine and paper book. I filed the paper book in the 2 appeal.
Both the appeals are ready.
Both the appeals are ready.
not received any paper.
Loss received already reflected in the order sheet. If not received, I serve another copy. Loss. I have no difficulty.
This is a appeal of in the year 93. I will fix a date for hearing of the
Loss.
appeal
Loss.
in the March. Okay. And I shall conclude the hearing on that date. Be ready, both of you.
Yes.
But in the meantime, he must have
Yes.
Yes, I will pass the necessary direction.
on both the appeal.
Very well, very.
I may be
Loss. In course of day, I
It serve in the course of day.
in course of day.
Okay. Can 2 of 2024 যা লিস্টে আছে তাই লিখে দিবেন ঠিক আছে দুটোই একই can দুটো This is an application under order 22 rule 10 read with order 1 rule 10 to CPC for addition of parties. it is the contention of the learned counsel for the applicants that appellant number 2 has transferred his right title interest over the suit property upon his legal heirs properly described at paragraph 2 of the CAN application. By the strength of a registered deed of gift dated 17th of October 2023, he submits that after receiving such deed of gift, the names of the applicants was correctly recorded in the heir record of rights. He further submits that the present applicants are the assignee over whom the interest of appellant number 2 has been devolved. So he prayed for necessary order for addition of parties. Next one, learned counsel appearing on behalf of the respondent raised strong objection and submits that the respondent number 2 has already been died. Full stop. The appellant did not take proper steps for substituting the deceased appellant, but only filed the application under Order 22 Rule 10 CPC. He submits that till the substitution be made in respect of appellant number 2, the application being CAN 2 of 2024 is not at all maintainable. Full stop. Having heard the learned counsel for the parties, it appears that the appellant number 2 has disposed of his right, title and interest over the suit property by way of a registered deed of gifts dated October 17, 2023 in favor of the present applicants. The copy of deed of gift has appended with the instant application. Having heard the contention of the parties, having heard the contention of the learned advocate for the respondent, it appears that the appellant number 2 has disposed of his right prior to his death. Thus, his right over the suit property prior to his death, thus the instant application under Order 20 Rule 10 is required to be disposed of. Under the above observation, the instant application being CAN 2 of 2024 is considered and allowed. Let the name of respondent appellant number 2 be struck out from the cause title of the memo of the appeal, and in his place the name of the applicant be incorporated, being appellant number 2A to 2D respectively. 2D respectively, ABCD, 2A to 2D respectively. The department is directed to make out the correction within a fortnight. Full stop. Next para. Learned counsel for the appellant submits that the appeal is otherwise ready for hearing. Full stop. TCR has already been received and he has already prepared the paper books. Full stop. Learned counsel for the appellant in SA 478 up to 1993 is directed to serve a copy of paper book upon the learned counsel for the respondent in the course of the day.
In course of day, yes.
In course of the day. Let the matter appear in the list under the heading of hearing. (21st of March).
After 25th.
After 21st.
25th.
25th. Then come on 28th of March under the heading of 2 we mentioned at 10:30.
Loss.
10:30. এটা আগে শুনুন। যত পুরোনো appeal শেষ করতে তত ভালো। Can 2024 সব ডিসপ্যাচ করো।
এখানে আসবে প্রথম সিস্টেম তাই
And same order, but
In the next matter, Lordship, here
appellant.
My learned senior friend appellant, here the respondent are 2, Naranjana Saw,
310.
310.
Consecutively, I am passing the order. In
Same
both
order, Lordship, only
the- in both the matters.
loss,
I am passing
both the
a
order-
single order in respect of both the matters.
loss,
Okay, I will hear both the appeals on that day.
loss.
And what is the status of 310 appeal?
Appeal was ready, same
He is the
LCR.
appellant. He is the appellant.
Well, I think he has prepared the paper.
I prepared
You
the
have
paper.
prepared the paper,
Yes.
then you serve it.
Yes, loss. Yes.
Same order.
My learned friend serve a copy of the paper.
Yes, I in course of the 2 paper book was sir.
Next,
And both the appeal will be heard together.
both
Together,
the appeal will appear on 28th.
loss.
Well, I'm for the respondent. Substitution application after 13 years. And what the explanation given is not at all satisfactory. It is totally contradictory.
Can 2,
Yes, no, I'm telling.
who is for the appellant?
Yes, not can too. It appears to appear on Pratiprotim Mukhopadhyay. No, no.
January 2007.
Yes.
This is my application.
Can 2,
Can 2 is my application.
yes.
Therefore, let him say whether he will file an affidavit or not.
Yes, I shall file.
Then that's all.
Lord, absurd.
You annex this document in your affidavit in opposition. That will be, I will give a reply to that.
Yes. No.
Otherwise, if he argue on the basis of that, I will not get the opportunity. Therefore, he is to file. Because it is a case of substitution by setting aside abatement, by condoning delay. Because your lordship knows 90 days substitution, 60 days
Total
for
150.
Setting aside abatement.
that is total 150 days. After 150 days, section 5.
Yes.
Accordingly, section 5 application was also filed.
You filed the section.
Yes, yes.
What is the can number?
Along with combined application.
No separate application.
No separate application, combined application
Combined prayer is
by
there.
condoning delay.
There is all right, madam. But explanation, Lord, if you on the very face, it is not clear.
You mention it in your opposition.
That's why, Lord, to fill up the.
So that, yes, so that you can fill up.
Yes,
Yes.
that is the sole intention.
Yes.
On the very face, the
Mr.
application
Ghosh-
is not mentioned.
Mr. Ghosh knows. For the check. Affidavit in opposition, reply.
Respondent is there leave to file affidavit in opposition within 2 weeks.
Yes.
Is there leave to file affidavit in opposition against Can 2 of 2025 within 2 weeks from it. Let the matter appear in the list on 21st of March
আমাকে দেখাবে না
under the same heading.
এই দুনিয়ার লয়াররা ড্রাফট করে বা দেখাবে নাই কি বলবো বলো তো গোপাল আর গোপাল আছে তখন মানে গোপাল ধরবেই কানটা আগে কানটা ধরে দিল কতদিন দিল গো
কত সেকেন্ড আপনি হিয়ারিং এ দিয়েছেন? একদম নেবেন না। সেকেন্ড আপিল হিয়ারিং যাই হোক নেবেন না, কোনো মেনটেনিং নেবেন না, বলে দিন জেন্টলম্যান। ইয়েস
My lord, in item number 10 and 11,
ইয়েস
Anima Bharadwaj died yesterday, my lord. Need to file a substitution
ওই
application.
জনিমা ভরতাজ
One of the appellant, my lord. Appellant number
appeal Learned counsel appearing on behalf of the appellant submits that one of the appellant has expired yesterday. Accordingly, he requires to take steps. Concerning the submission, the matter be adjourned today. Let the matter go out of the list, particularly limited mention.
My lord.
Next.
Item number 12 is that matter, my lord, which had come up with your lordship on the previous week. Your lordship may recall. আপনি বার হয়ে আছেন?
হ্যাঁ, এটা অন্য ম্যাটার।
My lord, there was this application, the second appeal, my lord, was admitted. After admission, it came before an honorable single judge, Justice Topon Datta, who passed orders. Thereafter, the matter appears to have been listed before Justice Rajshekhar Mantha's division bench.
Yes, yes.
And the division bench passed an order of dismissal for default. Now, I am saying that the division bench could not have assumed jurisdiction, but on that particular day, it appears that the division bench had logima jurisdiction. But as the list would suggest, that on that particular day, the matter had been not appearing under logima. It was appearing under for orders under the regular list. So there is now a confusion, according to me, slightly peculiar confusion as to who will restore it.
Yes.
If it goes before Justice Mantha, him having passed the order in his determination, apart from logima, where he didn't have jurisdiction, the order is non-est. If it goes there and then Justice Mantha sends it for the purpose of deciding what to do, then my lord, I am in trouble. So my lord, I wanted to first argue something which was quite cavalier, that is non-est in the eye of law, therefore my lord can proceed, etc. But I don't think I will need to take that far. My lord had been pleased to say on the earlier occasion that in view of this, my lord will place the matter before the Honorable the Chief Justice. Kindly do that, so that in connection with this application for restoration which I have, my lord is formally given the go-ahead to proceed. Then my lord will be sitting in the shoes of that honorable division bench, whether it had jurisdiction or did not have.
Yes, let me place before this honorable the Chief
Yes,
Judge.
but with a little bit of discussion, so that the assigning
I'll
person.
But before that, maintainability of the application, I'm ready.
তার জন্যও তো আপনার এই
1
লাগবে।
minute, please. No,
Yes.
no question.
Yes, what
Legal
is it?
question. It is a legal question.
Yeah, very well, I will answer.
Maintainability on a legal question. Sir, kindly come, my lord, kindly come to the cause title of the application for restoration. Come to the cause title of the application for restoration.
That is can 7,
Can
can 6.
okay. Can 6.
Yes.
Can 6, my lord. Can 6 cause title, respondent 1, A, B, C. Have your lordship got it? Mohammad Sukur, his heirs and legal representatives, Mohammad Joinuddin, Mohammad Kalimuddin, Salima Khatun. Got it, my lord. Lordship ka eta din na. We have intimated, though he knew it because he is the appellant, it is their duty, but we are the respondent group. Mohammad Joinuddin died. Naturally, this application for restoration at this stage cannot be taken up unless substitution is made within a period of 90 days. He is to make an application for substitution. This petition cannot be heard now. Everybody knows that. Practicing civil side. আরে তুমি অ্যাপ্লিকেশন ফর সাবস্টিটিউশন করো
পড়া আছে, এটা লিস্টেও আছে, আপনার কাছে কপি নাই, দে
দাওনি
7 of 2025.
ইয়েস ইয়েস ম্যাম
এসটি করে।
ও তাহলে ঠিক আছে,
যে হারাধন বাবু এলে আমাকে একদম শুইয়ে দেবেন ওই পয়েন্ট, একটু করে নিয়ে এসেছি।
সেটা দাওনি তো কপি।
ও দেয়নি, দুষ্টু ছেলে।
Yes.
না আসে 3-4 দিনের মধ্যে, ওর আসছে সপ্তাহ
Copy-
দুয়েকের মধ্যে ওর বিবাহ।
কপি ওয়াজ নট গিভেন, দ্যাট ইজ ওয়াই
ওর এখন মাথা ঠিক নেই, ওই জন্য আসছে 2 সপ্তাহের মধ্যে ওর বিবাহ। সিরিয়াসলি আমি
Very.
My lord, this is Friday, so sometimes we do a little bit of
This is good.
informal talk among
I
us.
understand.
And another thing
Lord,
I
we
have
are
to point
always,
out,
we are always talking
another thing
ourselves.
I have to point out, my lord, to your lordship, in your lordship's court, if a husband and a wife, both lawyers who are practicing, they sit separately, then they should be appointed joint receiver in the next matter. I can give you lordship example here and here, but they are sitting separately. So in the next matter where our lordship appoints a receiver, according to my lord's convenience, my lord may appoint them jointly as receiver. হয়ে গেল তো মামলা। একটু সাবস্টিটিউশনটা তাহলে অ্যালাউ করে
না একটু আমি দেখে নি ভাই
আবার দেখবেন
না ওই যে
আচ্ছা, তাহলে এক কাজ করুন my lord I
Let both the application being 6 and 7, I let the application being 6 along with the matter replies to the
Chief Justice, first let this come that
Thereafter I'll take up 6 and 7
let
both.
me see Lord because I know that there is a determination let him bring that
না না আমি নিয়ে এসেছি তো
list
আর লিস্টটা দেখান
if determination is not there
লিস্ট
then that can be no but no question of my Lord sending to the Chief Justice because this court has determination. This court has determination.
ডিভিশন বেঞ্চে জাস্টিস মানথা সাহেবের ডিভিশন বেঞ্চ এই দেখুন এই ডিভিশন বেঞ্চে ওটা ওল্ড হিয়ারিং ম্যাটার হিসেবেও আসেনি ফর অর্ডারস এ হঠাৎ এলো ফর অর্ডারস
ও তার আগে অর্ডার আছে
তার একটা ডিসমিস ফর ডিফল্ট হলো এটা তো এখানে হতে পারে না
না না তার আগে ওল্ড হিয়ারিং এতে তার ডিটারমিনেশন আছে
অর্ডার নেই এখানে
না না ওল্ড হিয়ারিং অর্ডার ইজ দেয়ার
বলছি আমি আগের দিনেরটাও তো আমি আপনাকে দিচ্ছি আপনি জোর করে করাবেন আগের দিন এটা দে লিস্ট আবার
2017
এই দেখুন
oh yes determination is there he is wrong totally wrong
ওরে বাবা
don't say like that first appeal first miscellaneous appeals and application connected up to 2017
হ্যাঁ তো এটা তো সেকেন্ড অ্যাপিল সর্বনাশ করেছেন স্যার শুক্রবার যা করছেন না এটা তো সেকেন্ড অ্যাপিল ডিভিশন বেঞ্চ আর ডিটারমিনেশনই
no
থাকে
let me look into that
আর কি দেখবেন স্যার
না আমার
অ্যাসাইন তো হয়ে যাবে। আচ্ছা ঠিক আছে জজ সাহেব
question of assignment because if
When the order was passed, dismissal order?
23rd of September 2024 and list of 23rd of September 2020 উপরে এরকম
because
একটা
we
জিনিস
could have
লাগিয়েছে,
pointed out
দেখে লোকে কনফিউজ হয়ে যায় এই উপরে এই টোপরটা কে পড়াশোনা করছে
if it is so my lord I will agree to that
কোনটা 23rd of September
I will look into I inquire into that your lordship fix it on next Friday if it is so I will agree to that because on that ground itself it is আরে ভাই আমাকে একটু দেখতে দাও
আর
না
কি দেখবেন নতুন
না ওরম ভাবে দেখবো না ভাই
কি দেখবেন
আমাকে একটু দেখতে দাও আমি জানি আজকে পিটিশনটা
এই তো স্যার
সাবস্টিটিউশন হয়নি সেই জন্য আমি বলেছি ওই পার্টটা তো দেখিনি আমাকে দেখতে হবে কেন এটা হলো
যাই হয়েছে ভুল
না
হয়েছে
না দেখতে হবে
ভুলকে দেখে
আরে
আপনি
না
কি করে
দেখে আপনি ইউ ক্যান ওয়েট ফর 1 উইক
দেখতে কি আছে আমার
বিকজ তাহলে কি আছে আর আমি তো এগ্রি করব
23rd of September.
ইফ ইউর
Kindly see
কন্টেনশন
the
ইজ
list.
রাইট I will
see the
agree.
list and kindly turn over the page. I have marked the application.
For orders,
Now, for orders is in
not in the logima matters.
No. That means for orders means his lordship is exercising his regular determination of first appeal and first miscellaneous appeal. There, my lord has dismissed my second appeal after admission.
No, you read the content of the order. The registry of this court has indicated that the registry has placed the matter.
If the RAC has placed the matter,
Yes,
not been placed
that
under
is
the
logima. That is logima.
had to be placed under logima. It has not. It has been taken as a for orders matter.
Oh,
I am confused. Accept.
order says.
Please, just a minute. The difficulty is today, if I go there, then I will be in a quandary because if I go before a division bench for recall of that order, it turns out not to be logima, there will be tremendous complication. In such circumstances, what is my prayer? Very innocuous. Someone has to hear this. According to me, any subsequent order after admission by second appeal has to be heard by a single bench. We are all ad idem on that. So now, because of this confusion of the logima determination appearing, allegedly, it has been sent up by the registry.
No, if it appears that the honorable division bench has dismissed the matter under the determination of logima, then also I have the determination to dispose of that matter.
Then your lordship has determination.
Yes,
Yes.
I am having the second appeal determination.
secondary
applications connection there too.
Yes, that
Then
is exactly I'm saying.
there is no difficulty. Then let us proceed.
Exactly, I'm saying
subject
yes.
Order is specific,
I-
maybe list is otherwise,
Ah.
but order is specific, the matter is placed through the registry. That means the logima.
Okay. Then my lord, there is no confusion.
Yes,
As
so it
far
is
as-
not necessary to place
Not
the
only-
matter.
So as far as CAN 7 is concerned, that requires disposal fast, as my learned senior friend has pointed out.
No, CAN
It is
7,
according to it
CAN
is
7 within 90 days. That CAN 7 হচ্ছে substitution.
substitution.
CAN 7 within 90 days.
Within 90 days.
Lord, it is liable to be allowed.
তাই তো
I
বলছি।
cannot object.
Liable না, entitled to বলুন।
No.
Entitled to be allowed.
Are liable, entitled,
is entitled to
thing
be
is
allowed.
same. Liable means liability in accordance with law.
Very well, I'm disposing of both the CAN 6 and CAN 7.
Yes, kindly first dispose of 7, then dispose of 6. এটা কি রিসিভ করি মেইন অ্যাপিলে আমরা এসে কন্টেস্ট করব। এখানে স্যারের রেট আছে, স্যারের সঙ্গে লাস্ট স্যারের এগেইনস্টে মামলা করেছিলাম, লাস্ট হচ্ছে
Please take down.
আন্দামানে যাওয়ার আগে। আপনার আন্দামানে যাওয়ার আগে না, আপনার লাস্ট
CAN
আন্দামানে
7 of 2025. This is an application for substitution of respondent number 1, Muhammad Jainuddin, who expired on, when he expired?
20th December 2024.
20th December 2024. The name of the heirs, legal heirs of the deceased respondent has mentioned in paragraph 3 of the application. The instant application for substitution filed within time. Accordingly, the instant application for substitution be allowed. Full stop. Department is directed to incorporate the name of the and strike out the name of the respondent number 1. Strike out the name of the respondent number 1, and in his place, the legal heirs of deceased respondent number 1 appearing in paragraph 3 of the CAN application 7 of 2025 be incorporated. The department is further directed to conclude the exercise within a fortnight. Accordingly, CAN 7 of 2025 is disposed of. Full stop. CAN 6 of
Now, with regard to 6, my lord, I have to say, give
Let
me,
me take out the 6.
give
Yes.
me, my lord, 1 week time, because why I am saying, first of all, my lord, your lordship, next week, so that, my lord, he may be directed to file the paper book. Because for non-filing paper book, my lord, it was gone to the division bench. That is why logima, they are delaying.
What
They
is
are the
the
appellant. We got the degree, which was affirmed up to appellate court. First appellate court. Again,
me
that
again
appeal has
order-
been referred.
ঠিক আছে, সেকেন্ড লেভেলের পেপার বুক তো দুখানা যা যা
Let him bring that paper book on that day, your lordship will allow it.
I
Yes.
accept.
Your lordship will, not
Yes.
today. Because if your lordship restore it, then again, my lord, there will be a default.
No, there won't be.
No, that cannot be.
এই সবকিছু
Lord, this is the way they are proceeding.
No, we are not. We are sincere.
They are
now, we
avoiding
are calm. No, avoiding. Yes, but my learned senior friend's suggestion is right. If for default of filing paper books, the matter had been placed in the logima, and if it has been dismissed for default, it would be apposite
Lord,
if I am
page 20, page 20 of the application.
কমপ্লিটটা করতে দিন।
subject to submission of paper book within 7 days?
Yes. So what my learned senior friend is saying is right. Kindly keep it after 7 days. Don't dispose it of now. We will come back with paper books. Second appeal paper book is only judgment decree, judgment decree finished.
Lord,
So it will be a thin paper book.
Informal paper.
We will make it within 7
Lord,
days.
your lordship, kindly look to page 220 of his application, CAN 6.
কি করতে চাই?
CAN 6. Kindly look into. Only one line. I can draw your lordship kind attention. Paragraph 7, page 20. Page 20, paragraph 7. The appellant shall file paper book in the matter mandatorily and positively within a period of
Page
2 weeks.
20.
Page 20.
Telling which the appeal shall stand.
Date 31/7/2022. The failing which the appeal shall stand dismissed.
The appeal was dismissed.
1 minute, please, sir. One minute,
Paragraph?
please. Paragraph 7, page
Yes.
20, paragraph 7. This is the condition mentioned in the order by the division
I am
bench.
accepting.
They did not comply
I
with
am
that.
accepting it.
No, therefore, the application be fixed for restoration on next Friday, they will serve the copy
Okay,
on,
I'm taking the
on
note.
that day. Your
I'm
lordship
taking note of your submissions.
I'm
Okay.
accepting it.
Yes.
Can 6 of 2025 is an application, 2024 is an application for restoration of the appeal, which was disposed of or which was dismissed for default by the order of the Honorable Division Bench sitting in the Lojima jurisdiction on 27th of September 2024. Full stop. Learned counsel for the appellant submits that the date, that is 27th September 2024, the list of the Honorable Division Bench has mentioned the matter for orders. Full stop. It was not placed under the Lojima matter. Full stop. The Learned Division Bench had no jurisdiction to dispose of the appeal without having determination of Lojima matters. This matters has placed under the regular determination, thus the impugn order itself illegal. It appears that after having heard the learned counsel for the appellant, it appears from the impugn order that the Learned Division Bench has started the impugn order with the remark, paragraph 1 ta likhbe within inverted comma, the registry of this court has indicated that 2 files of PCR in connection with title suit number 6 of 1988 have been received by this court. The initiation initiation of the order itself make it clear that the matter was placed from the registry under the Lojima jurisdiction before the Learned Division Bench. So the order passed by the Learned Division Bench under the Lojima jurisdiction, it appears to me correct. Full stop. This court has
not only another thing. Another thing, if your lordship kindly look to the prayer of the restoration petition, kindly look to that. Prayer.
I am
Prayer
not
is
disposing of
particularly-
I am not disposing of the restoration application. I am not today disposing of the application.
For restoration.
Yes.
করলে খুশি হবে না
Very well.
আপনার order এই অনুযায়ী পরের দিন রাখা হচ্ছে তো তাতেও আপনার রাগ
বললাম।
কি করলে আপনি খুশি হবেন বল
Correct. This court has determination of hearing second appeal and applications connection there too. This is an application in connection with the second appeal of 2006. So this court has determination to dispose of the application. Full stop. Next one. Learned counsel appearing on behalf of the respondent raised strong objection against the order of restoration on the ground that till the appellant has prepared the informal paper book and filed the same with the registry, the instant application for restoration cannot be allowed. I find substance in the submission of the learned counsel for the respondent. Accordingly, appellant is directed to prepare the paper book within a week. Full stop. Let the matter appear in the list on 7th of March.
I'm saying this I think the paper book will be post substitution. Therefore, I think it will be 1 week after 2 weeks because my lord has given 2 weeks for that change. Or if your lordship wants, I can incorporate it here.
Lord, when the substitution is allowed, department may be directed to.
I directed the department.
Thereafter, let
2
it
weeks.
come.
That is 2 weeks.
So I am fixing the matter on 7th.
7th,
After 2 weeks.
not 7th, my lord, I have some difficulty the next Friday.
কেন এরকম করছেন স্যার
7th to
Next Friday is the 14th. There is a holiday.
ফ্রাইডে দা 13th এর পরের দিন
14 দোলের ছুটি
দোলের মধ্যে কেন যাচ্ছেন স্যার কাইন্ডলি কিপ ইট অন 7 নো থাকবেন না
Then it will be on 21st.
বাবা 21 হ্যাঁ
21st
পরের 21 মার্চ
21st.
7 হলে হয়ে যেত
And another thing, Lord, let him correct it. Because this is, Lord, they are how they have been prepared this application, I don't know. Possibly my learned friend did not look into that.
না সে তো আগে
Lordship kindly, yes. Lordship kindly look into the preparing the restoration petition.
I am not disposing the restoration
No,
application.
no, may not be. But my Lord, the question would be order dated 23rd September, SAT, that is to be restored. And order dated 11th of September, this is
recalled হতো instead of
Oh,
saying
oh,
recalled
one minute.
it has been
No,
said
no, 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 no. I am not saying that. Lord, what I am saying,
no today
that-
my lord
no, no, kindly allow me to say,
So 23rd September is the order
no,
for
no, if you
dismissal.
want to have make a prayer for recalling the order dated 31/7/2024.
31/7, which order?
he's saying the earlier order of the division bench
31/7/2024, deemed dismissal, non-filing.
What is
Therefore,
What
yes,
what are you mentioning?
yes,
31/7.
yes, 31/7/2024, page 19. Kindly look to that. Deemed dismissal.
So it is not required to set aside that order.
No, it is required to recalling that part.
No.
By
Why it is? Why it is? I am directing the appellant to comply with that order. So what is the requirement?
আর এর আর কি
By-
চলছে এরা
yes,
বিশ্লেষণ
yes.
হ্যাঁ, ওই তো হয়ে গেল তো
No,
হয়ে গেল।
comply with this 30.
Direction, yes.
Very good.
আর কি আবার ওটারও রিকল চাইতে হবে তারপরে কমপ্লাই করবো আবার রিকল চাই
Don't
কি
over smart.
হ্যাঁ
Don't try to be over smart.
ওভার স্মার্ট না
Yes, yes,
আমি
yes.
এমনি
I'm
বলছি
telling that.
Okay.
No, don't say এমনি বলছি।
Okay.
আমি এমনি বলছি
Don't
Today
try
is the
to be
Friday.
over-
Okay. Today.
ওভার স্মার্ট না আপনি যে টেকনিক্যাল
no,
পয়েন্ট গুলো তুলছেন
Yes,
আপনার তোলা
right,
উচিত
right, because you
21st
have to
March.
make an application
শুক্রবার
for
দিন
recall.
ঝামেলা
March.
করবেন না
You have
শুক্রবার
to make an
স্যার
application
শুক্রবার
for
দিন
recall.
ঝামেলা করতে নেই আপনি যতই রেগে যান আমার কিন্তু আনন্দই হবে
21st March is the date.
21st. Yes.
Under the same heading. Under the heading application. Okay. Next matter.
Yes.
অবলাইশন নামগুলো দিচ্ছি স্যারের নাম
Lord, we are deeply obliged.
স্যারের নাম দিতে হবে কি বলছো ওভার স্মার্ট বলছে আসছে এদিকে আমাকে বলছে
কি করবো?
এবার আমি হাসিটা নেবো না গালাগালটা নেবো এই শুক্রবার দিন যে কি করছেন স্যার এদিকে বলছে ওভার স্মার্ট এদিকে হাসছে এদিকে গালাগাল দিচ্ছে হাসছে গালাগাল দিচ্ছে
Yes, item number 13.
But I appear for the petition.
I'm opposing.
What is the application?
Blood. Restoration of the appeal. If your Lordship kindly takes up my application for restoration. The application was not happily drafted, my lord.
Application for restoration can number?
This 4 is restoration. 5 is condemnation for delay. Now, admittedly, my lord, there was a delay. Now, admittedly, my lord, there was a communication gap with my lord, the first file advocate. And in fact, my lord, it was pointed out at the time of hearing before Justice Munshi in 2018. Now, if your Lordship kindly takes some at page 8 of the application, my lord, this is the order by which, my lord, court records triumphant satisfaction that the appeal should be allowed in first paragraph.
This order is tainted.
Now, my lord,
The honorable judge has not gone into the merit of the case, my lord.
This is order dated July 5th.
No, my lord, this is 5th July 2027.
2017.
2017, yes. Now, my lord, thereafter, my lord, if you kindly take the very next page. In 2018, I was appearing, my lord, because I was instructed to appear without having any vocaratnama, my lord. So, my lord, I made this submission before the court that I don't have any vocaratnama. That was recorded, my lord. And thereafter, matter was adjourned. Now, my lord, subsequently,
So you appeared on behalf of the respondent,
appellant.
appellant.
Yes. Mr. Ahmed, counsel for the on behalf
Okay.
of the appellants submits.
Appellant without any vocal, you have
Without a
submitted that you have not received any
I didn't
vocal.
have any vocal. There was a communication gap. That was the counsel was appearing, the advocate was appearing on behalf of the appellant, is in fact not practicing possibly in our court.
I join a issue, my lord. Litigant must be vigilant, my lord. The advocate knows, my lord, the matter is pending. The litigant also knows the institution, my lord. Not a village people that he don't know that the litigation is there.
Now, my lord, after this, my lord, the matter was dismissed for default. Since no vocaratnama was there, my lord, with me, I didn't appear, my lord. In subsequently November 2019, the matter was dismissed for default.
November 15th,
15 November, yes, ma'am.
2019, the matter was dismissed for default.
Now, all that I am praying today, that there is a prima facie case recorded by this honorable court for some latches. If I assume that there is some latches, I must submit that after this, I file restoration application, blood, and
How
that
many days delay is there?
Blood, there is long delay.
1010 days delay.
Long delay. Now, my
And
lord,
the entire allegation is upon the landed advocate.
on on several occasions, the matter was adjourned since the respondent was not appearing despite service. So, the restoration application could not be heard. In the meantime, the proclamation was issued. In the second suit, have you already seen the recording of this honorable court in 5th July order that there was second suit instituted, one suit instituted by them, which according to them is consequential to the decree passed in this suit. So this court recorded as a consequence of the decree obtained in this suit, a second suit was instituted for the monetary claim, and the decree obtained therein as such decree has been put into execution. There will be stay on operation of the decree in this case. As a consequence, the execution of the money decree obtained in this in the connected suit will also remain stayed. So that was the direction passed by this honorable court. Since that subsequent suit is consequential. Now, while restoration was pending, several occasions the service was made upon the respondents. Now, they didn't appear. Now, they put the interim order was expired. There was no interim order. Now, taking advantage of that, they was proceeded with the execution and proclamation was issued. That I brought to the notice of this honorable court. If you say kindly take some 6th January order passed by this honorable court on 6th January.
Well, the litigation is going on since 2007, my lord. For 18 years, my client is suffering, my lord. When I put the degree into execution, they woke up from a slumber, my lord. And now they are praying a stay of operation of the judgment degree passed in a separate money suit, my lord, in this matter, my lord, which is arising out of a separate suit, my lord. This is the second appeal arising out of a suit for
You are
taking.
mentioning item number, order number, order dated?
Now I am referring order dated, this is dated 6 January 2025.
Yes.
After adjournment of on several occasions, after issuance of proclamation, I mentioned the matter for reimposition of the interim order. This honorable court reimposed the interim order for the ends of justice, since they sought for using affidavit to my application for restoration.
No, without allowing the section 5 or restoration applicants, stay cannot be granted. That's what I have contended before the honorable court, my lord.
Now, 7th February 2025 order, all these points relating to money execution that was dealt in the order of Justice Sanjeev Banerjee as well as the order of Justice Chattopadhyay. It is 7th February 2025.
So now today.
All that I am praying today.
4 and 5.
Yes, ma'am. All that I am praying today, that let the appeal be heard on merit. I understand that there is a laches which is beyond the control of the appellant.
What is the grounds for delay?
The delay is about that long delay, 110 days, 1010 days.
5.
Yes, ma'am.
What is the grounds?
The grounds I have stated that only that communication gap between this is an institution where the change of administration goes on, they don't it was not explained in detail, but this is the
Kindly see paragraph 4 onwards, my lord. Page 5, paragraph
4 onwards,
No objection could not be obtained.
Yes, only after they receive the attachment warrant, they could file this restoration application.
But kindly once is paragraph 7, my lord. The applicant states that on September 19, 2022, the applicant could finally obtain vokalatnama from the erstwhile learned advocate. However, the same was dated August 2, 2018, since according to said learned advocate, he retired from the brief on and from such date. Only thereafter, the present application could be filed through the present learned advocate. But here I join a issue, my lord. It's a clever drafting, my lord. Absolutely, my lord, latches on the part of the learned advocate, erstwhile advocate, my lord. This is absolutely, my lord, not permissible, my lord, under the law, my lord. This is a clever drafting. I've brought those decision of the Honorable Supreme Court of Justice Krishna Iyer, my lord. Clever drafting, my lord. It should be nipped into the bud, my lord. Here, my lord, they are saying they don't have these or that, my lord. Thereafter, in the next paragraph, they are saying, my lord, the no objection vokalatnama is a backdated vokalatnama, my lord. And moreover, my lord, making allegation on the advocate is a very common thing, my lord. That also deprecated by the Honorable Apex Court in the recent decisions, my lord. I am relying on those two decisions, my lord.
Yes, very well.
I am a creator of Krishna Iyer. My lord, this is reported in 1978, Volume 1, Supreme Court Reporter, 742.
Yes.
If one of the meaningful non-formal reading of the
Paragraph.
plaintiff, paragraph, my lord, here, my lord, at page 744, my lord, in the left-hand column, my lord, G, my lord, 744, left-hand column G.
Placitum G.
Yes, my lord.
G, yes. Read out.
Here, my lord, it starts with the upper portion, my lord. My lord, I'm just reading it. From F, my lord, reading of closing a clear right to sue, he should exercise his power under Order 8, Rule 11, CPC, taking care to see that the ground mentioned therein is fulfilled. And if clever drafting are created, the illusion of a courts of action nip in the bud at the first hearing of the examining the party searching under Order 10 CPC. An activist judge is answer to irresponsible lawsuit. The trial court should insist imperatively on examining the party at the first hearing so that bogus litigations can be shot down at the earliest stage.
Yes.
That the next judgment, what I'm relying on, that is reported in 2025, Volume 1, ICC, 628, the Supreme Court decision, my lord. Paragraph 10 onwards, my lord. It appears that the entire blame has been thrown on the head of the advocate who was appearing for the petitioner in the trial court. We have noticed over a period of time a tendency on the part of the litigants to blame their lawyers on negligence and careless in attending the proceedings before the court. Even if we assume for a moment that the concerned lawyer was careless or negligent, this by itself could be a ground to condone long and inordinate delay, as the litigant owes a duty to be vigilant of his own right and is expected to be equally vigilant about the judicial proceedings pending in the court initiated at his instance. Here, my lord, they have filed this appeal, my lord. The litigant, therefore, should not be permitted to throw the entire blame on the head of the advocate and thereby disown him at any time and seek relief. Next, my lord, paragraph 11. In the aforesaid context, we may refer to a decision of this court in the case of Sholil Datta versus TM and MC Private Limited, reported in 1993, Volume 2, SCC, 185, wherein this court observed that the advocate is the agent of the party, his act and statement made within the limits of authority given to him are the act and statement of the principal, that is the party who engaged him. It is true that in certain situations the court may, in the instance of justice, set aside a dismissal order or an ex parte degree, notwithstanding the negligence and or misdemeanors of the advocates, where it find that the clients are the innocent litigant, but there is no such absolute rule that a party can disown his advocate at the time and at any time and seek relief. No such absolute immunity can be recognized. Such an absolute rule would make the working of system extremely difficult. The observation made in Rafiq AIR 1981 Supreme Court 1400 must be understood at the absolute proposition, must not be understood as an absolute proposition. As we have mentioned herein above, this was an ongoing suit posted for final hearing after a lapse of 7 years of its institution. It was not a second appeal filed by the villagers residing away from the city where the court is located. The defendant is also not a rustic, ignorant villager, but a private limited company. Here, my lord, the appellant is a institution within the jurisdiction of the Calcutta, my lord, with the head office at Calcutta itself and the management managed by educated businessmen who knows where their interest lies. It is evident that where their applications were not disposed of before taking up the suits for final hearing, they failed preclude and refuse to appear before the court. Maybe it was a part of their delaying tactics as alleged by the plaintiff. Maybe, may be not. But once things is clear, they choose to non-cooperate with the court, having adopted such a stand towards the court. The defendant has no right to ask it indulgence, putting the entire blame upon the advocate and trying to make it out as if they were totally unaware of the nature of the significance of the proceedings is a theory which cannot be accepted and ought not to have been accepted.
Yes.
Paragraph 12, as regards to law of limitation, we may refer to the decision of this court in Bharat Barrel versus Dram FMG Geo such and such, reported in 1971, volume 2, SCC 860, wherein this court held as under the necessity of enacting periods of limitation is to ensure that actions are commenced within a particular period, firstly to assure the availability of evidence documentary as well as oral to enable the defendant to contest the claim against him. Secondly, to give effect to the principle that the law does not assist a person who is inactive and slips over his right by allowing their when challenged or dispute to remain dormant without asserting them in a court of law. The principle which forms the basis of this rule is expressed in the maximum vigilance and vigilantibus and Timantuas Chura subvariants. The law gives help to those who are watchful and not to those who sleeps. Therefore, the object of the statute of limitation is to compel a person to exercise his right of action within a reasonable time, as also to discourage the suppressed state, fake or fraudulent claim. In view of the aforesaid, we find no error, not to speak of any of the error law, in the impugned judgment of the High Court warranting interference exercise of the jurisdiction under Article 136 of the Constitution of India. Hence, my lord, dismissed.
Yes.
In this case, my lord, High Court was pleased to dismiss the Section 5 application, my lord. My lord kindly comes to the application, my lord. Page 9, my lord, annexure B.
Can 5.
Can my lord, can 5, my lord.
Yes.
This is the order passed by Justice Munshi as his lordship then was, my lord. That is on 26 June 2018, my lord. There, my lord, they appear, my lord. They knows the litigation is pending, my lord. Even then, they are not taking any steps. Since, my lord, they are enjoying the order of stay, my lord. Thereafter, my lord, the matter was dismissed for default on, my lord, next page, page 10, my lord. 15/11/2019, my lord. November 15, 2019. That is about 508 days. Subsequently, the matter was dismissed. Within 508 days, my lord, they are unable to take instructions, my lord, from the asked by learned advocate, my lord. It is absolutely laches and negligence, my lord, since they are enjoying the stay order, my lord. In 2007, my lord, the plaintiff was terminated without any cause. The learned two courts in the courts below, my lord, held in my favor, my lord, relying on a rules, my lord, which was an exhibited document in the suits, that I have a right to challenge this before any court of law, my lord. So the learned court entertained, my lord. That, my lord, the tentative finding of Justice Banerjee of will nothing, my lord. It will hold no water, my lord. It's a tentative finding, my lord, that apparently the suit is not maintainable, my lord. The suit is very much maintainable, my lord. That this order is passed in connection with an application, my lord. The honorable judge has not gone into the merit of the case, my lord.
Yes. Anything?
This is, my lord, in connection with Section 5, my lord, I have stated. I've submitted.
Please take down.
Interim order is expiring today, my lord.
Can 4 of 2022 is an application for restoration of second appeal, which was dismissed for default by the order of this court dated November 15th, 2019. Next para, can 5 of 2022 is an application for condonation of delay for filing application being can 4 of 2022. Learned counsel appearing on behalf of the appellant submits that there are no intentional laches on behalf of the appellant to file can 4 of 2022 in delay. He expressed that the learned counsel appearing on behalf of the appellant on several occasions could not appear before the court due to his personal reasons, but it was quite difficult to obtain no objection from the learned erstwhile advocate. Accordingly, the appellant could not engage a new advocate. However, when they got the no objection from the erstwhile advocate, it appears to them suddenly suddenly the appellant received one warrant of attachment on September 10, 2022 from executing court. Thereafter, they immediately contact with the learned advocate and thereafter came to know that the second appeal had been dismissed for default on November 2019, November 15, 2019. It is the further contention of the appellants that on September 19, 2022, they received the Vakalatnama, they received the no objection, and Vakalatnama with no objection. But it appears that the same was dated August 2, 2018. Full stop. It is the further contention of the learned counsel for the appellant that there are no laches on behalf of the appellant. Moreover, the order of this court shall demonstrate that there are merits in the instant appeal in favor of the appellant. Thus, he prayed for necessary direction so that the appeal may be heard on merit by restoring the same. Learned counsel appearing on behalf of the respondent raised strong objection and submits that the learned apex court has time and again deprecated the stand taken by the appellant by placing reliance by placing all sorts of fault, all sorts of their fault upon the shoulder of the learned counsels. He further submits that the instant respondent is roaming to the door of the court since 2007. By the order of this court, the subsequent decree, the subsequent suit has also been stayed. He submits that the observation of this court regarding the merit of this matter is tentative in nature. It cannot determine the entire appeal. He further submits that the grounds as mentioned in Can 5 of 2024 is bogus one and cannot be allowed. In support of his contention, he cited the decision of Honorable Division Bench headed by Justice Krishna Iyer in P. Arivandhanam versus T.V. Satyapal, wherein the Honorable Division Bench has come on hardly, has remarked hardly regarding the clever doctrine which should be nipped in the bud. which should be nipped in the bud. NIPPED in the bud. He also placed his reliance upon the observation of Honorable Division Bench of the Apex Court in Rajneesh Kumar versus Ved Prakash, reported in 2025 within bracket 1, ICC 628 within bracket SC. Paragraph 10 to set of court. Paragraph 10 and 11. Paragraph 10 and 11. Learned counsel for the respondent submit that blaming learned advocate due to the laches of appellant is not acceptable ground in this case. Thus, the application being Can 5 of 2020, application being Can 5 of 2022 cannot be allowed. Having heard the learned counsel for the parties and considering the observation of this court, it appears to me that the appellant has demonstrated a fact regarding the causing of delay, that it was difficult for the appellant to collect the no objection from the erstwhile learned counsel. This reason, this is the only reason for causing delay. It is true, the entire period of delay, that is 1010 days, is placed to be the fault of the learned counsel appearing before the appellant on the earlier occasion. On perusing some order of this court, in the second appeal, it appears that a coordinate bench of this court, while determination of the second appeal on July 5, 2017, has observed some merit of the instant second appeal. However, on 26th of June 2018, Mr. Ahmed Learned Counsel appears before the court on behalf of the appellant without receiving any wakalatnama. On the alleged date, that is on November 15th, 2019, none appears on behalf of the appellant. None appears on behalf of the parties. Considering the entire facts and circumstances of this case, it is true that the observation of this court in July 5, 2017 is tentative in nature. No merit on record has been discussed in the state judgment. But so far as the conduct of the appellant is concerned, it tantamounts from order dated 26 June 2018 that Mr. Sameem Ahmed, Learned Counsel, appeared on behalf of the appellant without having any wakalatnama. It is well known to the it is known to the all concerned that Learned Counsel Mr. Jivan Ratan Chatterjee was not appearing in this matter since long. However, However, it is quite difficult for this court to disbelieve the fact of the appellant as stated in the application being Can 5 of 2025. It is also necessary to note that when appellant was aware about the mind of this court regarding the merit of this second appeal in his favor, why he should cause delay. Furthermore, the reason for delay has placed only on the basis of the senior advocate, basis of the laches on behalf of the senior advocate Jiban Ratan Chatterjee. Laches of the learned advocate Jiban Ratan Chatterjee, who did not provide no objection.
Not Jiban Ratan Chatterjee. That is let AP Chakraborty was the on record.
Jiban Ratan Chatterjee was there.
Was the counsel.
Counsel.
Yes. It was no objection was given by AP Chaudhary.
AP Chaudhary. Not
Orko.
Okay.
Orko Pratim Chaudhary.
Mr. AP Chaudhary. Concerning all aspects, it appears to me that the delay in causing the application for condonation of delay for long 1010 days, though on the part of the learned counsel for the erstwhile appellant, but appellant cannot disown his liability to proceed with this matter. Concerning the same, the application being Can 5 of 2025 is considered and allowed subject to the payment of cost of rupees 10,000. The appellant is directed to submit the cost of rupees 10,000 to the office of the State Legal Service Authority within 2 weeks. Let the matter appear in the list on 21st of March 2025 for further order. The appellant shall place the receipt of the payment on that date. Thereafter, the further order shall be passed. Next, interim order passed by this court shall be extended till date.
My lord, your lordship is extending the order, my lord.
Till date, till 21st.
Let interim order needs to be extended.
Interim order till 21st.
But only fixes the date for finally.
21st. You file the receipt, thereafter will pass the order. Next.
Receipt jama. চিঠি লিখে দাও।
What are the applications?
But this is my application. I am the appellant. There were 3 appellants, of which one of the appellant had died. But I got the information much later. And the legal heirs of deceased the appellant, they were unwilling to being arraigned as and substituted as an appellant. So I took out an application before your lordship to say that I require a substitution of the deceased the appellant number 2. And they, since they are unwilling to being arrayed as an appellant, they should be arrayed as a pro forma respondent in the appeal. Since there is a delay, I have prayed for a condonation of time and for abatement because the abatement has set in. So, my lord, this is my application in substance. My learned friend has come up with an opposition to say that, my lord, the right to sue does not survive because the legal heirs are unwilling to be substituted as a appellant here. So, my lord, we have also in our application stated that they are not
Where is
willing
the
to be.
objection?
Well, my lord, may I also file my reply? দুটো application? The application thank you.
Yes.
So, blood, my application is, blood, that since, blood, I have an obligation, blood, order 22, blood, to cause a substitution. Now, blood, it is beyond time. So, blood, I have prayed for a condonation of delay. Since it is beyond time under Article 121, I have prayed for, blood, and setting aside of an abbot. The reasons have been, blood, spelled out in my application. So, blood, since, blood, my persons, blood, who are sought to be, blood, substituted are unwilling to prosecute, blood, in the array of, blood, the appellant, I have asked for substitution and, blood, for transposition as that of, blood, the respondent in the appeal.
Appellant number 2, Gautam Sen.
Appellant number 2, Gautam. Your Lordship will kindly, at page 5, blood, paragraph 5. Then, blood, the explanations are contained at paragraph 7 at page 5. Then, blood, paragraph 8. Then, blood, the date on which, blood, I could obtain the death certificate, blood, that is on September 29, 2023.
Yes.
Then, blood, paragraph 10, blood, we say that the applicants thereafter send messages on several occasions through some common friend and relatives to the heirs and legal representatives of late Gautam Sen, seeking, blood, necessary instruction and cooperation from their end to enable the applicants herein to substitute late Gautam Sen, who was the appellant number 2 in the instant appeal by his legal by his heirs and legal representatives, but no response came from their end. That after waiting for more than 2 months, the learned advocate on record of the applicants herein issued a notice by registered speed post with acknowledgement due to the heirs and legal representative of late Gautam Sen on December 7, 2023, requesting them to give necessary instructions. Within 7 days of receiving the said notice, disclosing the stand that they want to take in the said appeal after the death of late Gautam Sen. According to the track consignment report, the said notice was delivered to the heirs and legal representative of late Gautam Sen on such and such date. Then, blood, paragraph 12, they have not responded. Then, blood, paragraph 13, that due to the reason as stated above, the applicant herein could not substitute the heirs and legal representatives of appellant number 2 after his death within the period as prescribed under Article 120 of the Limitation Act. That is on or before 28/11/2019. As a result, the said appeal has already abated as against the appellant number 2, late Gautam Sen. After 28/11/2019, the applicants herein could not file any application for setting aside the said abatement within period prescribed under Article 121 of the Limitation Act, that is on or before 27/1/2020.
Yes.
Due to the same reason as already averred in the foregoing paragraph. As a result, the delay of 1483 days have been caused beyond the period prescribed under Article 120 of the Limitation Act, and 1423 days delay has been caused in taking out an application for setting aside abatement occurred due to non-substituting the heirs and legal representative of deceased appellant number 2, that is Gautam Sen, and the same unless is condoned, the applicants will suffer irreparable loss and injury. Number, the prayers have been made. Number, the contention of my learned friend that, blood, they have only one fold, blood, the objection, as I find from their, blood, the opposition. They say that since the legal heirs are not interested, they have lost their right to sue, and therefore, blood, there is no necessity of substitution. Number, to which my answer is, blood, the substitution has to be caused, blood, by virtue of, blood, the provisions under Order 20. Now, the question here is whether Now, my lord, there are two my lord, possibilities. Suppose they are not my lord, substituted. So, my lord, one of the appellant goes out of my lord, the area of the second appeal. I proceed before your lordship with two of the my lord, the appellants, 1 and 3 before your lordship. If I succeed, my lord, the degrees are reversed. My lord, I can also proceed without my lord, the appellant number 2 in place. Now, my lord, why I say that appellant number 2, the legal heirs, my lord, they are required is, my lord, that since they were party in the trial court, in the first appeal court, but not interested in prosecuting the appeal as an appellant, but their presence is required as a pro forma respondent in the appeal. Therefore, substitution by under order 22 is required, and the transposition equally is for the reason that they are not willing to subscribe the Vakalatnama as an appellant.
Yes. Yes. Yes.
Now, my lord, this is the only point that they have taken. If your lordship kindly takes their lord, opposition, in their opposition, paragraph my lord, 5 at page 4. So far as the deceased appellant's legal heirs being prayed to be arrayed as pro forma respondents are concerned, it is stated that such contention is absolutely flawed and against the basic principles of law, as there would be two orders in the same appeal in existence at the same time, one in favor and one against. Therefore, the legal heirs cannot be impleaded in any manner whatsoever. Lord, I am at a loss to understand the contention here. I'll read it once more to understand, Lord, and comprehend, Lord, what they are trying to say here. It is stated that such contention is absolutely flawed as against the basic principle of law, as there would be two orders in the same appeal in existence at the same time, one in favor and one against. But in the second appeal, if I succeed on behalf of Lord the appellant number 1 and 3, I succeed as a whole. So, Lord, the substitution is a rule of procedure.
Their submission is, if you transpose the heirs of the appellant number 2 as a respondent, so if you got the decree in the second appeal, that would be the one against you and one against them.
Lord, if I get the decree, Lord, I have asked for Lord transposition as a Lord the pro forma respondent, not as Lord a dependent respondent.
And this is the
that is they are trying to say, but
yes.
Lord, I have never said that they should be Lord arraigned as a respondent per se. Therefore, their stand as they had in the lower two courts below, but that remains. Since, Lord, let us assume one thing. Lord, your lordship has, Lord, with my lord's vast experience seen, there might be Lord 10 plaintiffs. out of the 10 plaintiffs, if any one of the plaintiff is approved by the degree, he or she can prefer an appeal. The others are always, my lord, arrayed as a pro forma. So, my lord, that is the simple principle, my lord, I am trying to urge before your lordship.
Okay. Yes. Anything?
Lord, I will be just trying. Yeah, this is a very well settled, my lord, principle. I'm just, my lord, Lord, just citing one decision, Lord, on the point of, Lord, the substitution and, Lord, the abatement. Your lordship will kindly have a look at, Lord, 2021 volume 4 Supreme Court cases, page 246. But paragraphs, my lord, that I will be relying upon is paragraph 42 onwards.
Yes.
But your lordship may kindly, my lord, from paragraph 41. 2021 volume 4. The crucial question in this case is about the effect and consequence of the fact that legal representative of defendant number 2 had expired during the pendency of the appeal in the High Court were not brought on record. The rules of procedure for dealing with the death, marriage, and insolvency of parties in a civil litigation are essentially governed by the provisions contained in Order 22 of the Court.
Yes.
Though the provisions of Rule 1 to Rule 10A of the Order 22 primarily refer to proceedings in a suit, but by virtue of Rule 11, the said provision apply to the appeals too. And for the purpose of an appeal, the expression plaintiff defendant suit could be read as appellant respondent appeal respectively. Rule 1 of Order 22 declares that the death of a plaintiff or the defendant shall not cause the suit to abate if the right to sue survives. When read for the purpose of appeal, this provision means that the death of an appellant or respondent shall not cause the appeal to abate if the right to sue survives. Rule 2 of Order 22 of the Code orders the procedure where one of the several plaintiff or defendant dies and right to sue survives to the surviving plaintiff alone or against the surviving defendants alone. The same procedure applies in appeal where one of the several appellants or respondent dies and right to sue survives to the surviving appellants alone or against the surviving respondents alone. The procedure is that the court is required to cause an entry to that effect to be made on record, and the appeal is to proceed at the instance of the surviving appellants or against the surviving respondents as the case may be. However, by virtue of Rule 4 read with Rule 11 of the Order 22 of the Code, in case of death of one of the several respondents, where right to sue does not survive against the surviving respondent of the respondents, as also in the case where the sole respondent dies, and the right to sue survives, the contemplated procedure is the legal representative of the deceased respondent are to be substituted in his place. If no application is made for such substitution within the time limited by law, the appeal abates as against the deceased respondent. Now, my lord, thereafter, my lord, this is, my lord, the Supreme Court elucidates, my lord, each of the rules, my lord, under Order 20. Now, my lord, here, your lordship will see, in a case where, my lord, the defendant has to be, my lord, substituted, but it is also, my lord, to be seen whether the right to sue survives as against the deceased defendant or not. But in this particular case, my lord, as I have said before your lordship, my lord, I was one of the plaintiff I was also, my lord, one of the appellant in the lower court below. And I had died, and because of the unwillingness of the heirs, my lord, I can not only be arrayed as an appellant. So, my lord, there is a necessity of substitution in a sense that, my lord, Order 22 requests, my lord, a substitution. Therefore, my lord, the point here is whether by way of a substitution, whether I should be an appellant or I should be arrayed as a party, my lord, by way of a pro forma respondent.
Yes.
But that is the only point here. So, my lord, since they are unwilling to be arrayed as an appellant here, by executing vokalatnama in favor of the advocate on record, but I am constrained to take out this application to say, kindly substitute, set aside the abatement, arraign them as a pro forma party here. Because the most German thing is, not for me, is to have the appeal heard without not the legal heirs of the deceased appellant number 2 or with the deceased appellant number 2. The legal heirs of the deceased appellant number.
Okay. That's all.
Lordship.
But I appear for the
Lord,
respondent.
in my reply, I'm just Lord, in my reply, Lord, I'm prompted, Lord, 2 hours. Lord, raised before your Lordship, Lord, paragraph 10. This is more in the nature of an argument than a statement in pleadings.
Yes.
Lord, the second part of paragraph 10.
Yes.
Lordship. But that is all for my submission.
I appear, my lord, for the respondent number 2 and 4.
2 and 4.
2 and 4. Here, my lord, admittedly, this gentleman has died in the year 2019. The death certificate or the cremation certificate is at page 11. Now, there's a delay of 1400 days in filing this appeal, this application.
Yes.
First, my lord, that the explanation that they have given is that they were well aware of the death, but they were asking for the death certificate, or they were initially not aware of the death, but they were brothers. They are brothers. They were aware of the address because letters has been written to them for consent by the legal heirs to join as an appellant here. The lawyers have written letters. So parties were well aware of the address of each other, of the legal heirs. Now, and they waited the second appeal of 2012, even the death is in 2019, for 1400 days, which is 5 years nearly, to file this application after the death. Now, and I say the explanation which is given over here, the appellants are not diligent. It's your appeal. You should be diligent to come before the court. It's not the lawyer's fault or any other fault. If the appellant is, the party is not diligent to conduct his case, so what's the result? Now here, the second issue is, my lord, that one appellant has died. The legal heirs do not want to join. I am never saying the appeal has abated. Can't be. But it has abated so far the gentleman who has died is concerned. Now today, he has to be brought on record what my learned senior friend said, that as a pro forma defendant. Now then, at the same breath, he is seeking a setting aside of the abatement. Now if we read Order 22, the Supreme Court decision is on where a defendant expired. So Order 22, Rule 4 applied because the defendant. Now here, Order 22 from, if I read 1, 2, 3, 4, none of these provisions apply to the case in hand.
It is for appellant. That means Order 22, Rule 2 and 3.
Yes, if the 3 applies, my lord, where there are more plaintiffs, he is a plaintiff in the court below.
Here appellant.
Here appellant. Say Order 11. And the right to sue does not survive, or the sole plaintiff on an application made on that behalf shall caused the legal representative of the deceased to be made a party and said proceed with the suit.
That is.
Where within the time limited by court, no application is made under sub-rule 1, the suit shall abate so far as the deceased plaintiff is concerned. And the application of the defendant, and on the application of the defendant, the court may award him and incur against the defendant, recover the estate of the defendant. So I'm not on the last two lines. So the suit will abate so far as that plaintiff is
Deceased
concerned.
person is concerned.
The deceased person is concerned. Now, if the legal heirs of the deceased are not willing to join as a plaintiff, let my learned friend continue with the second appeal with the striking of the name, recording the death of the deceased. Now, today, what I say, my lord, today he has been made a pro forma defendant. So he is made a party to the proceeding. He is not appearing. Now, in the both quote below the decree of affirmation in my favor. Now, today, after the decree is passed, if my learned friend succeeds in the appeal, or if it doesn't succeed in the appeal, they are parties to the proceeding. Another round of litigation will invite another round of litigation. The pro forma defendants are there in the parties. If you are not interested, your name is struck off, you're not a party. As Order 20, Rule 3, the first provision, your name is struck off, you're not interested to be another party. Now, putting them as a pro forma defendant, yes, will once again invite a future litigation. That's my humble submission. Okay. Now, he seeks a setting aside of the abatement, so they get the right in the suit also. The legal heirs are party. In any event, we do a pro forma defendant, but in this situation when they don't want to join, it is not that during the pendency of the second appeal they expired. Initially, their father joined as appellant. Now, the legal heirs are not willing to. Now, they have written letters to the legal heirs. Now, if I go back to my first defense, if a party is not diligent, I'm not blaming the other brothers. The gentleman who died, his legal heirs. If he's not diligent, what is the effect? Effect is Rule 3. You delete your name and we can proceed with the proceeding. The appeal, even the entire appeal won't abate. That I am not at all. The appeal has to be heard. The paper books are ready. The papers in file also. We have served the paper book. Now, their name can be deleted, my lord. And this condonation of delay of 1400 days, once again, I go back to the same way that you should be diligent to, your brother died. It's not that your brother died, you knew the address, you have sent letters to your brother's legal heirs and everybody. Please give the address, whether you are willing to join as a appellant or not. So, my lord, if the name is deleted by recording the name, that's my humble submission, my lord, the name be deleted in the array of the appellant of Gautam Shen under Rule 3. That they are not willing to join, because that's the averment here. That there is no response from their side. Paragraph 10 last line and paragraph 12. They have not responded in the petition.
Okay, hard. Anything?
No.
Okay.
Because the decision which friend submitted is the defendant died. The defendant died. There may be a delay, abatement, interest of justice. Those can come in if a defendant dies. Right to sue survives. Those are settled. But if somebody is not willing to join, I can't force him to come. And the first rule 1 of sub-rule 1, of Rule 3, if I say. These are my submissions.
Yes, Mr. Mukherjee, any reply?
After understanding what my learned friend has said, but there are two things. If my learned friend says, Lord, there will be a deletion of name of Lord, the appellant number 2, very well, that has to be done. Now the question is, Lord, in the event my learned friend succeeds in the appeal, and Lord, the decree is Lord, put into execution without the legal heirs of Lord, the deceased appellant number 2,
On
whether my learned friend can at all not put the decree into execution in their absence. That is a risk. If my learned friend want to take, is welcome to take the risk.
But I'm a defendant
That is
in the
not.
suit. I won't get a decree. I'm a defendant in the suit. If the decree will, even if the decree goes, we will go to him. The declaratory decree he wants. I can't execute a declaratory decree. He wants a declaration in the main suit. I'm a defendant. I will never get a decree. I will never get a degree.
Okay, hard.
So I cannot
But I
execute
can give you
even
a
the declaratory degree, even if he gets a declaratory degree. The declaratory degree cannot be executed in any event.
Very
My lord.
Okay, thank you. Please take down. Can 2 of 2023. This is an application for substitution in respect of date of appellant number 2, namely Gautam Sen. After setting aside abatement, comma, upon condonation of delay of 1483 days, and with a prayer to implement the legal heirs of the said deceased appellant number 2 as the pro forma respondent in the memo of the cause title of the appeal. The contention of the appellant is that appellant number 2, Gautam Sen, expired on 30th of August 2019, leaving behind the legal heirs mentioned in paragraph 5 of the application. Since last 2 years before the death of Gautam Sen, the relationship between the applicants, that is the other full brothers of Gautam Sen, became strained due to some difference of opinion and some family issues. The appellant number 1 and 3 had no interaction or connection with deceased Gautam Sen. For that reason, the appellant do not have any knowledge about the death of their brother Gautam Sen till April 2023, which they came to know from their common friend. When they came to know about the death from their common friend. However, they got the copy of death certificate of late Gautam Sen on September 29, 2023, and informed the legal heirs of the deceased appellant by issuing a registered notice for making party in the making party as an appellant in the instant second appeal, but the heirs and legal representative of deceased appellant number 2 have not responded. It is the contention, it is the admission on part of the appellant that there are a delay in filing the application for substitution of 1483 days. So he prayed for necessary order for substitution, and with a further prayer, necessary prayer for substitution after setting aside abatement by condonation of delay, and with a additional prayer to implement the legal heirs of deceased respondent appellant number 2 as pro forma respondent in the cause title of the memo of the appeal. Full stop. Learned counsel, Mr. Mukherjee. appearing on behalf of the appellant submits that the strained relation between the brothers could not bring the knowledge of the death of appellant number 2. Moreover, the attitude of the legal heirs of the deceased appellant number 2 is the only reason for filing the application in delay. He submits that the present appellant number 1 and 3 has no intentional latches in filing the application in delay. So he prayed for necessary order for latches in filing the application in delay. So he prayed for necessary order for substitution after setting aside abetment by condonation of delay. Learned counsel appearing, Mr. Mitro, learned counsel appearing on behalf of the respondent submits that the appellants were not at all diligent. The deceased person is the full brother of the appellant number 1 and 3. They had the knowledge of the death of appellant number 2, but they intentionally filed the application in delay, only to delay the proceeding. He further submits that the application being Can 2 of 2023 cannot be considered and allowed. Reasons thereof, as the legal heirs of deceased appellant number 2 did not want to proceed further with this appeal, so they lost their interest in the appeal. Accordingly, right to sue never survives. He submits that the name of appellant number 2 may be expunged by making necessary remarks in the cause title of the memo of the appeal to be deceased. He submits that the appeal may be proceeded by appellant number 1 and 3. He again submits that if the legal heirs of the deceased appellant number 2 were impleaded as pro forma respondent, the complicity would be arise if the appellant get the decree in the second appeal.
Sorry, Malad. Once recording my submission that for setting aside abatement, the legal heirs must come in and ask for setting aside.
Okay.
Whether somebody else can ask for setting aside or somebody else's abatement.
Okay. He further submits that the legal heirs, as lost their interest, are required to file the application for setting aside abatement on the death of their father, as they have not appeared for filing any applications. So the application being Can 2 of 2023 cannot be allowed. Next one. Having heard the learned counsel for the the respondents filed affidavit in opposition against the application being Can 2 of 2023. Reply against such affidavit filed by the appellant is also taken on record. Next one. Having heard the learned counsel for the parties, also considering the pleadings, also considering the applications and affidavits thereof, it appears to me that the provision under Order 22, Rule 3, CPC is applicable in case of death of one or several plaintiffs or of sole plaintiffs. Good stop. Order 22, Rule 11 speaks that an application under Order 22 shall applicable in the appeal, and in that case, the word plaintiff within second inverted comma shall be held to include as appellant, and the word defendant, comma, a respondent, and the word should within inverted comma, an appeal. So truly, Order 22, Rule 3 is the applicable provisions for dealing with the instant application. To decide the issue in hand, it is required to set out Order 22, Rule 3, CPC. Set out. Order 22, Rule 3 within bracket 1 disclose that if the right to sue survives, the court on an application made on that behalf shall cause the legal representative of deceased plaintiff stroke appellant to made a party and shall proceed with the suit stroke appeal. Order 22, Rule 3 has codified very consciously, and it has not imposed duty upon the legal heirs of the deceased to file an application. It said an application made on that behalf. It said an application made on that behalf to invert comma that tantamounts that surviving appellants stroke plaintiffs, surviving plaintiffs stroke appellants may file an application for substitution, or the substituted or the legal heirs of a deceased appellant may also file an application. The last line of the said provision is very important. It enumerated within inverted comma shall cause the legal representative of the deceased plaintiff to made a party and shall proceed with the suit. Inverted comma says. So it has denoted that the legal representative of the deceased plaintiff stroke appellant has to be made a party. It has not codified to mention that the substituted legal representative should be made as a plaintiff or defendant stroke appellant or respondent. So it is true that the legal heirs of deceased appellant may be made a party to the party as pro forma respondent, or may be made as a party to the appellant. There is no bar in the provision to making party as pro forma respondent in respect of the deceased, in respect of the legal heirs of the deceased appellant who are not interested. Next paragraph. In the in deciding the second question, it appears that the person appears that whether right to sue survives if the legal heirs of a deceased appellant denies to enter in the appeal as they lost their interest. Full stop. As they lost their interest. Full stop. Right to sue in a civil suit is civil suit denotes that right to filing a suit or right to the suit property in question. the right over a suit property devolves automatically upon the death of a person to his legal heirs. The devolving of the right of a property upon the legal heirs is automatic upon the death of a person. That is the reason the right to sue term has been incorporated in the in order 22 of the Code of Civil Procedure. Whether the legal heirs of the deceased appellant are at all intending to proceed as an appellant or not, but the right to sue shall always survive upon them, unless it can be shown that the deceased appellant has lost his right over the suit property during his lifetime. Thus, in my view, the right to sue must survive upon the legal heirs of the deceased appellant number 2. Next paragraph. In considering the diligence of the appellant in filing the application, it appears that the application is filed after 1483 days delay. It is true that the appellant has demonstrated a fact that they were unaware about the death of one of their brother. The registered copy of registered consignment copy of registered letter which was posted in the name of the legal heirs of the deceased appellant number 2 is placed with the Can 2 of 2023. The conduct of the legal heirs of the deceased appellant number 2 itself proves the strained relation between the appellant and the deceased appellant number 2. However, the Honorable Apex Court in Peruman Bhagavati Deswan, এটা লিখে নেবে একটু, তুমি লিখে নাও, Peruman Bhagavati Devaswam, DEVASWOM versus Bhargavi Anna, BHARGAVI AMMA, within bracket 2008, 8 SCC 321, has held that within lack of diligence or negligence can be attributed to an appellant only when he is aware of death and fails to take steps to bring the legal representative on record. Full stop. Where the appellant, being unaware of the death of the respondent, does not take steps to bring the legal representatives on record, there can be no question of any want of diligence or negligence. In the present fact and circumstances of this case, it appears that the appellant has successfully demonstrated the fact that they were unaware about the date of death of the appellant number 2. Thus, it appears that by virtue of the decision of Honorable Apex Court, in as mentioned above, the application file for substitution is considered and allowed. Full stop. The abatement, the abatement abatement is no, the application for substitution be allowed by setting aside abatement upon condonation of delay of 1483 days. Full stop. The appellant is at leave to implead the legal heirs of the deceased appellant number 2 as pro forma respondents. Appellant is further directed to make out the correction of the cause title of the memo of the appeal within a week. Full stop. The appeal is otherwise ready for hearing.
My lord, the paper
Let the
books,
appeal be placed for hearing on
Paper-
7th of March. Are
maybe
you ready, both of party?
after the dole, after the dole.
Since my learned friend is busy, will be busy in not that.
any
Then come on 21st.
21st, what is?
21st.
After
Paper books are ready?
Yes, paper আছে না এখানে?
Ready.
দেখুন না paper book আছে।
Paper book ready. Paper book.
হ্যাঁ, paper book ready।
Paper books are ready.
paper book এসে LCF তো সবই এসে গেছে নিশ্চয়ই।
Can 2 of
Paper.
2023 is disposed of. 21st.
21st,
Under the heading of hearing.
oblige।
I'm grateful.
ডিপার্টমেন্টে যাবে কালেকশন
ওটা বলে
বলেছি এক সপ্তাহের মধ্যে
শুধু আমার মাথা খারাপ করে যাবে
oblige।
I'm grateful.
কবে কবে কবে
21শে মার্চ তার মধ্যে কারেকশন।
Next matter. Order 22, Rule 3. Right? Take the judgment.
This matter, Lordship, we are the respondents, Lordship. We have mentioned the matter because even after the death of the sole appellant, Lordship, no step has been taken. So we have filed an, Lordship, application for recording of abatement. Now, for the Lordship,
Item number
15, Lordship. On behalf of the appellant, Lordship, earlier occasion, Mr. Aniket Rokit was appearing, but due to illness, Lordship, he is irregular. We want to, Lordship, serve directly upon the Lordship, the legal heirs of the deceased appellant.
have you served?
No, Lordship, first time appearing, Lordship, so we have to serve. Instead of the learned advocate, Lordship, I want to serve directly upon the parties.
It is not necessary to record the abatement.
Because-
Abatement is automatic.
Yes, Lordship, because now the appellant is not coming forward for
Then
Lordship
appeal will be
substituting.
disposed of as default. Why
Now,
abatement
default
is required to be
Because
noted?
pending this appeal, pendency of this appeal, Lordship, we are suffering, Lordship. That's why we have to prepare this.
If the appellant is not coming, I can dispose of the appeal.
Now, Lordship, we can do one thing, Lordship. We can serve the copy of the application. If the legal heirs come and Lordship
If
want
you
to
want
serve.
the appeal be heard on
Yes,
merit,
yes,
then
yes.
then you have to take light step. Okay,
Yes.
okay, very well. Decision can 2 of 2023. This is an application for recording of abatement of the instant appeal, which was automatic due to the death of sole appellant.
Sole appellant, Lordship.
This is an application. Next paper. This is an application filed by the respondent. Respondent is directed to serve the application upon the legal heirs of the appellant through register post and file an affidavit of service on the returnable date. Let the matter appear in the list on 21st of March
Grateful.
under the same heading.
Good.
Lordship,
Call next matter.
Lordship, one small indulgence, Lordship. Lordship, item number 2, Lordship, have passed over.
Item number 2 passed over.
Lordship, I tender my apologies for not appearing at the time of when the matter was called, Lordship, due to some Lordship, this is an application. We have made an application.
You are,
I am for the respondent number 8.
who is for the appellant?
Lordship, the appellant has died in the year 2009. Lordship, we have
You
prayed.
mention this matter.
Lordship, yes, Lordship.
Why you appear, why it is appearing under the heading of to mention? You
Lordship,
mention this matter.
yes, Lordship. The matter was mentioned.
Who mentioned this matter? Respondent.
Lordship, respondent number 8.
What is the name? What is the name? This is your mentioning slip. দেখানো থেকে।
My signatures.
Item number 2.
Lordship, we have preferred this application, Lordship.
What application?
For abatement, Lordship. That was mentioned, Lordship.
Abatement is automatic. If the appellant has expired, then automatically it would be abated.
Lordship, the appellant has died in the year 2009, December 27, 2009, and no further steps was taken, Lordship.
Were there any steps taken?
No further steps were taken by the appellant, Lordship.
When he expired?
December 27, 2009. The death certificate
Similar
is
order,
annexed.
you file the, you serve the applications upon the legal heirs of the deceased. Can 3 of 2022?
Yes,
Can
one.
1 of 2022.
Yes, can 3 is appearing in the. Can 3 is, what is it for can 1?
Can 1 is an application, Lordship, at the instance of one of the respondents that the plaintiff had, so I beg your pardon, my lord, the appellant has expired and no steps have been taken for his substitution. So it may be, the appeal may be dismissed as abate.
Who is the appellant expired? Name?
Pranab Kumar Ghosh.
This is application being can number 3.
Can 1, my lord.
Can 1?
Can 1 of 2022.
There is no such can 1 2022, can 1 1999, and can 3 2022 you are submitting.
It has been noted in my brief. Is it an application, Lordship? May kindly.
For appropriate order.
Yes, yes.
Can 3 is there.
Oh,
It is running in the list, can 3. Can 1 2022, no such. What are the other can applications? When he expired?
My lord kindly takes up can 3 then at page 6, annexure A, on the 27th of December 2009.
Pranab Kumar Ghosh.
My lord.
Memo. Yeah. নাম্বার কত? এই ক্যান গুলো কোথায় ডিসপ্লে ফেলছে? 2 old can 8583. If the appellant is not taking steps and he expired, the abatement is automatic.
Lord, for that, my lord may kindly pass necessary orders and dismiss the appeal, lordship.
If you
Because-
try to proceed with the application, then application has to be served. Otherwise, I can dismiss the appeal for default.
My lord may kindly do that.
What you want? If you want to proceed with this application, I will direct
Let
you
it
to
be dismissed for default.
dismissal. Please take down. This matter appearing under the heading of we mentioned. It is the contention of the learned advocate for the respondent that the sole appellant of this matter of this appeal has expired on December 27th, 2009. No application for substitution has been filed. Moreover, the appellant is not appearing before this court since long. This prompted the appellant and the respondent to file an application being Can 3 of 2022 for dismissal of the appeal by recording the abatement or the learned counsel for the appellant. Peruse the death certificate, place along with the application. Peruse the copy of death certificate, place along with the application being Can 3 of 2022. It appears that the sole appellant has expired. No application for substitution has been filed. Moreover, the appellant is not taking any steps concerning the same. The instant appeal B and the same is hereby dismissed for default. Connected applications, if pending, are also disposed of. Interim order, if any, passed by this court during the pendency of the instant taken appeal is hereby vacated. Next para. PCR, if received, be sent down promptly to the learned advocate.
I am very grateful.
My lord, 17 January allowed my mentioning application that today my matter will be listed, my lord, after 5th matter. Well, unfortunately, my today in the list, my lord, 27. Well, he is a senior citizen, my lord. Day by day, my lord, he comes. My PR before this honorable court, my lord, that matter will be fixed, my lord, Friday, 12:30, my lord. It will be possible,
When?
my lord. My lord,
2:30,
12:30, my lord.
12:30.
30, Friday,
Cannot
my lord.
fix the matter. What is the matter?
My lord, second appeal, my lord.
It is listed in the matter.
Listed in matter.
Then what is the
27.
number?
27. Item 27.
Item number 27. Item number 27.
27, my lord.
Yes, it is in the top 5, but I could not reach there.
But if it was possible, my lord, next Friday, my lord, 12:30, my lord. Because my lord, he is a senior citizen. My lord. Day by day, he comes before this court, my lord.
Why the purpose of coming the parties to the appellate court?
My lord, my lord,
This is not the criminal court. Why are you bringing the senior citizen in the court?
my lord, my lord, he
It is not
wants
necessary
start
to
his
come
case.
it is not necessary to come to the court. If you
I
are
know that,
diligent
my lord.
enough, the matter can be proceeded.
You want to hear the appeal hearing. That is
Very
the
well. That is the other issue altogether.
Yes, my lord.
So item number 27.
My lord.
What is your name? Ki naam apnar?
Nomita Maji.
আপনার স্ত্রীর নাম নমিতা মাঝি। আপনাকে অ্যাপিলে আসতে হবে না, উকিল অ্যাপিল হিয়ারিং করবেন। যদি আপনি শুনতে চান তাহলে আমি ডেট দেবো হিয়ারিং এর, যেদিন অ্যাপিলটা হিয়ারিং হবে। শুনতে চান আপনি? ভেরি ওয়েল। Then come on 17th of March, that is Monday 10:30.
10:30.
Okay. On mentioning item number 27, we fixed for hearing of appeal at 10:30 as a special fixed matter. Appellant is directed to serve notice upon the respondent for the for fixing the date of hearing.
My lord. Item number 1, my lord, I beg to appear for the petitioner, my lord. I appear for the beneficiary in the probate application, my lord.
Beneficiary of? Beneficiaries of?
Of the probate, my lord.
Beneficiaries
Of the will, my lord. Lord,
Your Lordship,
there are two full submissions, my lord, which I may make, my lord. GA number 7 is appearing in your lordship's list, my lord. GA number 7 is a restoration application because the matter was dismissed for default, my lord. There are 3 orders, my lord, which I'll take your lordship through to, my lord. My lord, kindly have a look at page 29, my lord.
Your Lordship, if I may submit, we have not been served a copy.
They have not been served because they are not on caveat. There's no
Lordship,
caveat.
GA number 395 of 2012 that was appearing in this PLA. Your Lordship, that we have filed, that is an application for condonation of delay to lodge wakalatnama and caveat, your Lordship.
That is pending.
Lordship, that is pending.
And that till that there's no caveat. So, my lord, I don't require to serve, my lord. Kindly have a look at, my lord, page 29 once, my lord. My lord, order dated 28th November 2024, my lord. GA number 2, old GA 395, which is their application, which they just referred to along with PLA, my lord.
GA number 2 of 2012.
12. This is their application.
Lordship,
Seeking
yes.
GA 395 of
Yes,
2012.
Yes, this is their application. And the main PLA appeared 105 of 2011. None appears on previous occasion, also none appeared. The matter is dismissed for default, my lord. Thereafter, my lord, your lordship will kindly turn over to Annexure H, page 30.
So the matter was dismissed for default.
Yes, on 28th November.
That is PL 105 of 2011.
When GA2 also appeared. Thereafter, on the next page, PLA 105 of 2011 appeared. And there was an order. Report is called for from the Testamentary Department on lodging of caveats and service of citations. The report shall also contain whether there are paper publication intimating the probate proceedings. Report shall be placed. And the advocate for the, my lord, beneficiary had also appeared. So, my lord, there was, my lord, bona fide, my lord, belief that perhaps it is the GA which was dismissed on that day because the main matter appeared. However, on the next date, 14th January.
Lordship, if I may submit, your
My lord,
Lordship.
I have not yet
Lordship,
I have not
kindly,
completed, my
because
lord.
in
I have not yet
if
completed,
your
my lord.
Lordship,
My lord, this is my application, my lord.
Lordship, I am just submitting that they have not served the copy, and I will show that we are on caveat. Your
They are not.
Let me ascertain.
Lordship.
So, my lord, I showed your lordship page 30, my lord, that the main PLA appeared, but GA2 did not appear. And an order was passed, my lord, page 30. Thereafter, my lord, there was a clarification, my lord, Annexure I, my lord, wherein, my lord, the Honorable Court, my lord, clarified. In terms of the order dated 28th November, the whole matter was dismissed for default, including GA number 2. And PLA number 105 of 2011, in view of successive non-appearance, the matter should not appear in the list any longer. So when on 14th January, my lord, the Honorable Court was pleased to clarify that the entire matter, along with the application, was dismissed for default, my lord. It is at that point of time, my lord, we took out this application for restoration, my lord. Today, my lord, since, my lord, my PLA application has been dismissed, I have preferred GA7, my lord, seeking recalling of the order of dismissal and, my lord, restoration of the original PLA matter, my lord. That, my lord, your lordship will kindly allow, my lord. And they have not taken out any application for restoration of their GA.
Lordship, Lordship, till the time the main PLA is restored, we cannot take out any application for restoration.
I understand. What is the matter PLA?
105 of 2011, your Lordship.
For what?
My lord, for probate of, my lord, the, my lord, will
Kishori Lal
of
Jalan,
Mr.
your lordship.
Kishori Lal Jalan.
Probate application.
Yes, which was later.
You are the petitioner to the probate.
I am the beneficiary. The executor was discharged, and the PLA was converted to one for letters of administration.
Very well. And you are?
Lordship, the caveator. Now he's
They are
saying,
not the
Lordship,
caveator.
they are saying that we are not the caveator. Lordship, our application was dismissed. Lordship, by an order dated. Our application being GA 395 of 2012 was dismissed. Lordship, by an order dated 16th June 2015. Your Lordship, thereafter we had preferred an appeal, and by an order dated.
What was your application?
Lordship, for condonation of delay in lodging.
Condonation of delay.
In lodging wakalatnama and caveat, your Lordship.
So
Lordship, this order, the order dated.
Appeal, you went up to appeal.
Lordship, yes, your Lordship.
What is the order of appeal?
Lordship, the order dated 22nd September 2021. Your Lordship, Mr. Chaudhary, the learned counsel appearing for them, submits a caveat was filed on 21st November 2011. The application for probate having been filed earlier on 20th May 2011. This line in itself proves that a caveat was filed and we are on caveat. Lordship, we could not file an affidavit because of which affidavit supporting caveat, your Lordship. Because of which, Lordship, sorry, apologies. If I may show your Lordship this order.
So what is the final order?
Lordship,
allowed.
The appeal and application are disposed of. The Lordship. The interlocutory court will deal with the application on benefit of facts noted above and observations made. It was, Your Lordship, restored. It was set aside, the order for dismissal, Your Lordship.
And GA 395 is to be considered a fresh, my lord.
Lordship, he is submitting that we have not filed any application for
Okay, you filed the copy of application G.
Lordship.
You want to use affidavit?
For
Against the
restoration,
GA?
they themselves they couldn't restore their
Let it be
application.
restored.
Yes, Your Lordship.
Today I can dispose of the GA7.
Lordship. Lordship.
If it is restored, automatically the whole application will be
Restored.
I
Yes,
have
Your
not,
Lordship.
I have not prayed for that, my lord, in my master summons.
It is
Lordship,
not
but in
necessary to praying.
yes, Your Lordship.
The
If the
clarification of order is very much clear that the earlier occasion, that the last order,
Yes. Both the
GA and the PLA 105 of 2011 has been disposed of.
Yes.
Both are.
Lordship, in case the PLA is restored,
Now,
the GA will automatically get restored,
Today,
Your
my
Lordship.
lord, I can only show, my lord, reasons for my non-appearance as the petitioner in PLA, my lord, which I will justify, your lordship, whether it was, my lord, bona fide mistake on my part and whether your lordship can restore my PLA. What was the reason for absence of my learned friend in their application has to be justified by them. There is no such application to that
Lordship,
effect before this honorable court.
Lordship, I am just praying.
Yes, what is the ground?
My lord, your lordship will kindly have a look, my lord, at page, my lord, page 9. Sorry, my lord.
In that case, Your Lordship, I am praying that let a copy of the restoration application be
Yes, you
served
have a-
upon us, and thereafter
There's
we
no
will come back,
caveat.
Your Lordship.
There's no caveat, my lord, as on
Very well,
date.
you serve a copy. He has appeared, so you have served a copy.
Your lordship will not restore, my lord, the application, my
Lordship,
lord.
in that case, he is submitting that in case PLA is restored, GA cannot be restored.
GA7, you serve GA7.
Lordship.
You serve GA7 2025.
Lordship, may kindly keep it next week. We will come back, Your Lordship. With a direction
My
upon
lord-
them to serve a
My
copy
lord,
upon
may
us.
I just request your lordship to have a look at the endorsement from the department, my lord, which is on the back side of the application, my lord. On the back side, it says there's no caveat, my lord. The department has acknowledged, my lord, no caveat, my lord.
May there be no caveat.
Lordship,
but
there
he
is an
appeared, you file a copy. You have to serve a copy to him, at least.
My lord, paragraph 22, my lord, page 8, I have stated, my lord. In this regard, it is respectfully stated that the learned advocate engaged on the matter, my lord, inadvertently failed to take note of the matter, my lord.
Very well.
Kindly, my lord, restore the PLA, my lord, so that
Lordship,
this matter
kindly
can be
direct
proceeded
them
with.
to serve a copy upon us, and thereafter you can, Lordship can restore it on the next date, Your Lordship.
Well, what is the locus as on date, my lord?
Lordship, there is an application, there was an application that was pending in this PLA, Your Lordship.
Which has not yet been allowed as on date.
Lordship, that cannot be decided. If the PLA is allowed, that application is automatically restored, Your Lordship.
Such a you are fighting with each other without going to the merit of this matter.
We want to proceed in the merit, my lord. Your lordship kindly restores and fix the matter, my lord. We'll
Lordship,
That is the only purpose the
Yes.
matter should
Lordship
be
can restore, Lordship, if your Lordship pleases, Lordship can restore that GA and Your Lordship. We
No,
can,
No,
in that case,
taken at chronologically. Very well.
Lordship.
Please take down. PA7 of 2025 is an application for restoration of PLA 105 of 2011 by setting aside an order dated 18th November 2024. Applicant of GA2 of 2022 appears.
Lordship 2012.
2012 appears. The petitioner of GA7 of 2025 is directed to serve a copy of application upon the applicant of GA2 of 2012 within 2 working days. Let the matter have working days. Let the matter appear in the list on 7th. No, 28th. 28th February 2025 under the same heading at 2 p.m.
My lord, since your lordship has directed us to, my lord, serve, my lord, I'll serve, my lord. Your lordship will only, my lord, record my submission that it was not served because they are not on caveator, my lord. That submission, your lordship will kindly record, my lord.
Okay, I will take. আগের প্যারাটা কি বলেছি ফার্স্ট প্যারাটা ইলেভেন না 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 ঠিকই বল applicant of GA2 of 2012 appears বলেছি না দেখুন দেখুন appears full stop করুন petitioner ওইখানে অ্যাড করুন ওইখানে তারপরে অ্যাড করুন petitioner submits that petitioners of GA7 of 2025 submits that the copy of application could not be served upon the applicant of GA2 of 2012 as there are no caveat considering the submissions of the parties তারপর petitioner হ্যাঁ
Grateful, your
My
lordship.
lordship is giving it after 1 week, my lord.
Yes.
Sir, grateful, deeply obliged.
within 2 working days you serve the copy.
I'll serve it today itself, my lord.
Grateful, your lordship.
কি এটা এটা আমার কাছে কেন এসছে হ্যাঁ বুঝতে পেরেছি কেন এগুলো এসছে আমার কাছে This is the matter personal grounds. Dismiss করেছো তো আমি শুনবো কি করেন স্যার
May it please your lordship, and this is Mr. Surana's section 34 application against the same award.
Yes.
During the course of his 15 hearings, he has made enough submissions on this.
Let me just assess the
Yes,
what is the rounds.
Yes, because his 15 days, we finished reply in less than half a day. But I'll let him. I'm grateful. Anything else? All else.
This is my application, my lord, 822 of 2016. Yes. This is an application filed by me under section 34 against the award passed by learned arbitrator on 19th of May 2016. Yes. And against the said award, respondent number 1 and 4 have also filed an application, which is 700 by 216. And respondent number 2 and 3 have also filed an application, which is 698. The new number is 135 2000. 698, that is 135, the arguments are already over. Sufficient. What I wanted to humbly submit before your lordship, during the course of hearing, your lordship must have assessed. There are two main things. I say they are in possession. They say they have delivered the possession. This is one. The second item is that they say whoever is in possession, I'm not liable for his liability. These are the two main things, Miller. I will submit briefly on these two counts that they are in possession of the premises, number one, and then they are liable to make the payment of the. Now the issue is that you have prepared an application under section 34 of arbitration and conciliation, Miller, challenging some finding of the learned arbitral award. So you first assess me what are the grounds you challenge the arbitral award, so that we can proceed accordingly. What are the grounds? You have contradicted their grounds on your way. There are now we are on the session over the matter. I know the award, what is the award, everything I know. I everything know regarding your contentions and bone of contentions. That is the rival contentions of the party. But what are the grounds in this application? Well, here the grounds are. But that means what you challenge, what finding you challenge here. Yeah, that is what I'm saying. These are varying from award to award. There is not only one award. There are various claims, and all the claims have been considered and awarded separately. Some of the claims have been admitted. Some of the claims have not been admitted. So some of your claims was not admitted by the arbitrator. Yes, my lord. For which you have filed this, my lord. And I have also. What are the claims? That would be proper for hearing of this matter. I will. You understand the issue? I will come to that. What I wanted to humbly submit before lordship. Two main issues are there. Let me finish that, and then I'll take each and every claim separately, and I will explain why I am. No, I want to know what are the claim first. Gist. What are the claim here? Thereafter, you can proceed your argument. $698 achieve. 698. 22.
So far as the aspect of my liability for alleged continued possession is concerned, that forms part of the second arbitration reference in respect of that section 37 appeal, where I was addressing your lordship. Continued liability. That, my lord, with greatest amount of respect, perhaps will not come within the ambit of the section 34 filed by Mr. Surana.
That's why I want to know what is the grounds here in this matter. My lord, kindly come to page 65 of my petition. $65 is the page 8 of the award. Yes, my lord, page 8 of the award. Now, my lord, here, this is a chart which is shown from, which starts from page 8 and it concludes at page 10. Yes, altogether there are 33 items, my lord. 33 items, right? Now, my lord, here I have stated, assuming license fee from so and so period to so and so period, then interest, then again another clause is there, another claim is there, license fee from so and so date to so and so date and interest thereon. So there are not 33 claims. There are altogether, my lord, 15 claims. Out of that, 5 claims have been admitted. Yes. Out of these claims, my lord, 5 claims have been admitted. One claim is for license fee. I have been awarded for lock-in period for 5 years. Then I have been awarded for electricity charges. Then I have been awarded for water charges. Then I have been partially awarded for extra works which I have undertaken on their request. And then the last item is additional license fee which has been awarded to me.
Interest on additional license fee like that.
Yes, this is additional license fee and security deposit and interest there.
Interest there.
So these 5 claims have been admitted.
Yes.
Awarded. Some of them, and the electricity charges, water charges, electricity charges have not been awarded in full. As far as license fee is concerned, it is for 5 years. And as far as additional license fee is there, that whatever claim I have made, it has been awarded in full. Likewise, they have also raised something around 19 claims. Out of that, their 5 claims have been admitted. One is for their license fee. One is amount paid to Shrey International. Their claim starts from page 60, page 67, my lord.
Yes.
Internal,
Paragraph
page
16.
Yeah.
Page 10.
Page 10, my lord. Page 10 to 19. Now their claim is for some 362 crores.
Yes.
Out of that, my lord, the learned arbitrator has awarded them on account of some license fee and loan to the extent of 3.53 crore. And then some amount was paid to Shrey, which I have consented. An award has been made for that. Then an award has been made for, they have made certain payments to Roy Industries and others to the tune of about some 35 lakhs. That has been admitted. And then the security deposit which I have deposited, which I have received from them, some 64 lakhs, award has been made for that. And then the outstanding CAM charges payable by one of the stores within the premises.
Yes.
That has been allowed. The rest of the claims have not been allowed. So I have taken in my application all these claims. I will be challenging the claims which have not been admitted, my claims which have not been admitted, and I will also be highlighting about their claims which have been admitted.
Yes.
Now, all the claims have been considered separately. So the points for rejection or point for challenge are also different from claim to claim, my lord. I'll come to that.
Yes.
Now, my lord, while the arguments being made in respect of the earlier application, their main contention was that Mr. Surana has not been able to establish that they are in possession of the premises. And I say that they are in occupation of the premises. Now, to that, they have issued a letter, my lord, on 12th of April 2012. I'm a disclosure of documents. Page 11.
Yes.
No, my lord, they are relying on this document
And vociferously they are saying that the learned arbitrator has accepted in paragraph 33 of the award that the possession have been received by Mr. Surana on the basis of this letter. Now, my humble submission is, my lord, this letter of 12th of April 2012 was only an expression of offer. Page, that is page 11. No. Disclosure আমার ছোট যে আছে বড় যে আছে বড় না 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 একটা দুটো ডিসক্লোজার আছে একটা লিগ্যাল পেপারে আছে হ্যাঁ এটাই পেজ 11 দেখুন এটাই আছে এটা 16 আছে yes কি দেবো হ্যাঁ 12th April 2012. Miller. Now, when this letter was issued, that shows they were in possession of the premises, Miller. Yes. This is undisputed. So when this letter was issued, they were in possession. I need not to establish that, Miller. They themselves have established that they were in possession of the premises. This is number one. Number two, Miller, in this letter they have stated, with reference to the above, please note that we are ready and willing to hand over the licensed premises to you under the aforesaid agreement in accordance with our terms, in accordance with our termination letter. Now, your Lordship would remember they have issued a termination letter on 31st of October, wherein they have claimed something around some 25-26 crores of rupees. And then they have stated this termination is forthwith. And if the termination is forthwith on 31st of October 2011, I really do not understand what is the meaning of issuing a letter on 12th of April 2012. In any way, they have issued this letter. You are advised to be present on 14th of April 2012 at the Puja Mall office premises so as to enable us to hand over the premises to you. Yes. So they wanted to hand over the premises. Now, this premises can be handed over in the manner in which they have received it. They cannot say that my people will be there, you take possession. I will come to interim award where the things have been explained thoroughly by the learned arbitrator, my lord. So my humble submission is, my lord, respondent number 2 was fully aware that the contents of it cannot be complied with. As I said, this is an offer expression that I will deliver the possession on 14th of April. There is no document on arbitral record. There is no evidence that they have delivered the possession to me on 14th, except that 33 clause, para 33 of the award says that it appears that the possession has been delivered. As such, the finding of the landed arbitrator in paragraph 33 of the
So
award.
whether you challenge that finding in that in this 34 application?
Yes, my lord.
You have also challenged this finding?
Yeah, yes, my lord.
In this 34 application?
Yes, my lord. Yes,
okay. So you have to mention that you have only stated about the claims, not the finding.
My lord, when I will be referring claim, when I will be coming on my license fee, this position would be cleared. Because license fee, the learned arbitrator has made an award for 5 years. And learned arbitrator has also...
Entire lock-in period, the award has been given to the license fee to you.
So in that, this will be covered, my lord.
Okay. So you have, okay.
So what I wanted to submit, my lord, the finding of the learned arbitrator in paragraph 33 of the award is rendered in absence of any evidence of delivery of possession to the claimant, contrary to the agreement terms, and without application of fine, thereby rendering it perverse.
Okay, finding at paragraph 30.
33, my lord.
Para 33.
The act of the award. Paragraph 33.
Find out the
another award, our petition.
Paragraph 33.
Page 78, my lord.
Yes.
Well, at paragraph 33, the learned arbitrator states, it is significant to note that the said clause E22 also entitles the respondents on determination of the agreement to remove and take away all its goods, articles, fixtures, and likewise. Likewise, they were also entitled to refund of the security deposit paid by them in terms of clause E5 of the agreement. By the letter dated 12th of April, the respondents expressed their readiness and willingness to hand over the licensed premises to the claimant. Now, the learned arbitrator is very categorically writing that they express their readiness and willingness to hand over their licensed premises to the claimant in accordance with the termination letter dated so and so, which is what I have submitted right now. Requesting the claimant to be present on 14th of April 2012 at Puja Mall. None apparently turned up. In such circumstances, the respondents justifiably contended that possession was in effect handed over on 14th of April. It is not his finding, my lord. It says that respondents justifiably contended that the possession was in effect handed over on 14th of April. The claimant, by his letter dated 19th of December 2011, written in reply to the termination letter, accepted the termination, but raised various claims and exercised lien on basis of said LS outstanding dues estimated at rupees so and so over all goods, materials, equipments stored in the scheduled premises, adding that security deposit would be refunded only upon payment of such outstanding dues and with interest at the rate of 18% per annum. This is what 33 says. Now, kindly come to
in your letter dated 19th December, you have accepted the.
I have not accepted. This is what they say.
So this is the award said. Award said that
he has come to the finding that since I have not said that I do not accept, he has come to the conclusion as if I have accepted because I have raised my claims also. Now, kindly come to paragraph 37, my lord. In any event, there were combination of circumstances which made it impossible for the respondents to give vacant possession of the demised premises to the claimant. And not all of those were their own making. Undoubtedly, the respondents could not deliver vacant possession of the scheduled premises for the reason as would appear from correspondence exchange between the parties. Now, very categorically, it is stated the vacant position was not delivered. In 33, the finding is respondent contents justifiably delivered. In 37, the finding is it was not delivered in vacant position. In terms of the contract clause 22 of the agreement, the possession has to be delivered, returned back in vacant and peaceful condition, as they have taken from, and upon settlement of all my outstanding dues and removal of their articles from the premises. It was not done. So what I humbly submit, my lord, that there is no evidence on record on which arbitrator has come to a finding that respondents justifiably condemned that they have delivered the possession. He has very categorically stated that it is an expression of offer. Respondent's contention is there that we will deliver on so and so, and the finding is they have accepted the contention. And there is no document, there is no evidence that I have received the possession. No document, no evidence. And the area is, my lord, over 1 lakh of a square feet. Yes. Now, finding in paragraph 37 of the award to the extent that the petitioner R2 failed to deliver vacant position of the claimant appears to be wholly based on evidence on record as well as terms of the agreement and with application of mine and possibly upon the adjudication of so and so, so and so. My lord, when the interim award was passed, volume 2, page number which আমার interim award হচ্ছে page 167 থেকে আরম্ভ হচ্ছে। Page 171 এ চলে আসুন। 171.
This is the interim award.
This is an interim award, my lord. Now, this will thoroughly explain the position, my lord. So, let me complete it first, my lord.
Yes.
Kindly come to paragraph 9, my lord.
Interim award.
Interim award. As paid at page 171.
Yes.
The matter was taken up for hearing on 19th March 2013 when learned counsel for the claimant fairly conceded at the outset that in view of the complexity of the matter, the stage at which the proceeding has reached and in absence of fuller argument and discussions of all evidence, both oral and documentary before me, it would not be right to press for any monetary award as claimed in prayer A of the application. My lord, my interim application, which I made for interim award, had two main prayers, one for payment of dues, one for delivery of possession. So A was for monetary claim, my lord. He, however, insisted that by virtue of a clear admission contained in the letter dated 12th of April 2012, written by and on behalf of the respondent number 2 and addressed to the claimant, recording that the said respondent was ready and willing to hand over licensed premises to the claimant granted to the respondent number 1 in terms of agreement dated 30th of January 2007. Kindly note that to hand over the licensed premises to the claimant granted to the respondent number 1 in terms of the agreement dated 2007, there should not be any impediment in the passing of an award in terms of prayer B of the said application for this peaceful and vacant possession of the licensed premises. Now, my lord, your lordship is not having that interim application. Let me give you a copy of this interim application, my lord. You want a copy? Interim award for 23 crore and for peaceful and vacant possession. This is an application I filed for interim award. This is a copy of interim application. Kindly come to the prayer portion, my lord. Yes. Prayer A. An interim award for rupees 23 crores 95 lakh 50,719 as pleaded in paragraph 3 along with interest in terms of the agreement dated so and so. Prayer B. An interim award for fast, peaceful and vacant possession of the licensed premises more fully described in the schedule annexed hereto and marked with the letter D. Kindly come to D, my lord. The last page, my lord. Yes. It's a schedule, my lord, of the entire premises. Yes. So the concluding portion of paragraph 9 of the interim award is there should not be any impediment in the passing of an award in terms of prayer B of the said application for fast, peaceful and vacant possession of the licensed premises. Right, Milord? The next para is licensed learned counsel for the respondent number 2 conceded to the said position. A very important, my lord, to note that they conceded what is there in clause B of the application. Your lordship will remember, my lord, when I was making submissions, I said that they have not delivered me the position. Mr. Medola said we have delivered the position. Then during course of my argument, I have shown certain arbitral minutes wherein their counsel have said no vacant position have not been delivered. He changed the scene that no, we have not delivered the vacant position, but then we have delivered the position. I really do not understand what is the meaning of position and non-position. So my humble submission is paragraph 10 of this interim award is very important. Learned counsel for the respondent number 2 conceded to the set position. What position is prayer B of the interim application? And prayer B of the application says that vacant, fast and peaceful position would be delivered of what? Of the premises which were delivered to R1 in terms of agreement dated 2007. Yes. 11. I am accordingly inclined to pass an interim award in terms of prayer B of the said application. So an award was passed in terms of B, my lord, and B was conceded by the respondents. And B is for fast and peaceful and vacant possession of the premises. I, however, make it clear, quite clear, that the reservation made by the claimant in his letter dated 14th of April 2012 in response to the letter dated 12th of April of the respondent number 2 is kept open for adjudication. Yes. So my humble submission is, my lord, rather my apprehension that when the finding was recorded in paragraph 33, it was without any application of mine, without adjudication of these 2 letters. And when a finding was recorded in 37, it has been very clearly stated that it has not, vacant position has not been delivered. So I believe that by that time, he must have adjudicated upon this, but then there is no evidence in the record. Yes. But finding says, finding makes it clear that it was duly considered. Then only he said that vacant position was not delivered. Now, my lord, further evidence, and as far as this termination letter is concerned, I have stated they have given go by to that termination letter, because on 12th of April, sorry, on 14th of Oh, no, sorry. Now, as far as the delivery of position is concerned, another evidence is there, my lord. Volume 10. 1415 ভলিউম 10 1415 তো ওইখানে আছে 135 এ আছে তা কি আনানো যেতে পারে The further evidence on record is that the petitioner, that the respondent too, made over the position of the demise premises to the association. My lord, this is the cross-examination of their witness. Yes. Mr. Anil Cherian is a company secretary, my lord. Refer answer to petitioner's witness question number 255, my lord. 250, the question is, you refer to making over position to an association. What is that association? Witness explains the circumstances in which, on public demand, an association being Puja Mall Retailers Association was formed, and the respondent number 2 made over position to the association. Now, their witness says that the position was delivered to the association, and respondent in this honorable court says that the position was delivered to Mrs. Surana. And then he says position was delivered, vacant position was not delivered. I do not know what they will submit tomorrow. I may therefore submit that if position was not delivered to the association, then how R2 could offer position to the claimant on 14th of April 2012? Therefore, the finding of the learned arbitrator in paragraph 33 of the award is contrary to the evidence, terms of agreement, and without application of mine, and therefore rendering the same perverse and patently illegal and thus required to be set aside. Yes. In answer to question number 254, my lord, the petitioner's witness stated that the entire property was sub-licensed and nothing remained with the R2. Now, if the entire premises have been leased out by them, what position they will deliver to me, my lord? When they don't have anything to be delivered to me, it is the evidence that the entire premises was sub-licensed. R2 had nothing at his command. Now, I have stated, my lord, that the interim award has been passed on consent. Then R2 could. Now, this question was raised in a section 9 proceedings also, my lord. I have initiated section 9 proceeding after this award was made for the subsequent license fee. They have said they have delivered the position. I produce interim award. The honorable judge asked, you have to demonstrate that you have delivered position post interim award, because during the interim award you have stated, I am conceding to give you the position, I am accepting to give you the position, means you were in possession of the premises. They could not make any answer to that, my lord. Yes. And the relevant order also, my lord, that is 23rd of April 2019, I have filed. Can I just place it before the auction?
Relevant order in section 9.
Yes, my lord.
No, not necessary.
I filed it is in the
now
record.
You have to deal with the point which was taken by the arbitrator regarding position.
Yeah,
only this point.
So this
not the subsequent order was passed by
fine.
the.
So I have explained.
Yes.
Interim award is very clear, my lord.
Yes.
And what they have conceded to the interim award is also very clear.
Yes.
And I have also stated, my lord, that the finding of the learned arbitrator recorded in paragraph 33 was without application of mind, without any evidence, contrary to the evidence, contrary to the terms and conditions of the agreement. Hence, perverse and patently illegal is liable to be set aside.
Yes.
And if I may be permitted to say, my lord, the 33 is not actually the finding of the arbitrator. It is a contention of the respondent which have been recorded. And they are taking undue advantage of that. The arbitrator has held this.
Okay, you proceed on your way.
Volume 11. Paragraph 8 has happened. Next page.
Okay. Paragraph 33 to 37 is a common finding. Very well.
Yes. 33 to 36 and 39 is all on their hearsay. And 37 is the finding.
33 to 37 is the common finding. Common factor, that is possession.
Yes, ma'am.
That was dealt with by the learned arbitrator.
Now, here, my lord, in this 38th and 39th, their counsel has accepted for justified circumstances his client was not able to give vacant position to the claimant. It's a clear admission. Then, of course, I have placed this in the last hearing. This is the my lord 70th sitting. Here it is stated on the question whether actual physical possession could be made over to the claimant. Mrs. Saha points out that by exercising their lien over furniture, fixture, fitting located in the mall premises, the claimant prevented the respondents and enabled himself to obtain actual physical possession. Significantly, the right of claimant to exercise his lien over the furniture, fixture, fitting of the respondents in the mall premises has been upheld by the Honorable Court, and the said order is subsisting. Both the arbitral sittings were held on after 12th of April and also after 8th of April. So the 70th sitting was held in late 2015, my lord.
Yes.
There also he has said, I have not been able to deliver the vacant position to the premises.
Yes.
Now in paragraph 37 of the award, my lord, the arbitrator is very categorically recorded at any rate following the interim award passed by me on 8th of April 2013, declaring that the claimant was entitled to khas and peaceful possession of the licensed premises. No attempt was made by the claimant to evict such sublicensees and occupiers of the said premises till date. Now, this is what his learned arbitrator is writing on the 19th of May 2016.
Yes.
Which categorically demonstrates that the mall was thoroughly occupied by the occupants created by R1 and R2. Now, my lord, when a decree of eviction is passed, that is applicable to the sublicensees also. And it is the duty of the main tenant or main sublicensee to remove them. I cannot go and ask each and every sublicensee that you go. It is his duty. The eviction order is applicable on one and all residing in the premises or occupying the premises. And why I did not take any step, my lord? Because it was a consent award. They said, we will give you the position. So if they will give you the position, who am I to initiate steps for evicting them? They did not take any eviction. They did not take any steps to evict them. It was their duty. It was their undertaking before the arbitrator.
So sub-licenses were inducted in by the strength of supplementary agreement.
So they have created, my lord?
Yes.
They have created. Now they say that they have terminated their license. And they were asked to vacate the premises on 31st of March 2012. That is also there recorded in the minutes. Now, if then they becomes unauthorized occupants, and if they're unauthorized occupant, it is the duty of the main sublicensee to remove them, my lord. They have given an undertaking to the arbitrator.
Yes.
The petitioner's learned counsel, while making submission on 26th of July 2024, has stated that the learned arbitrator notice deemed position. Another type of position has come in. Mr. Mukherjee has stated on 26th of July that arbitrator notice deemed position on 14/4/2012. And thereafter further submitted that position was delivered on 14/4. On the one hand, he says deemed position, and then he says it was delivered on 14/4. Very difficult to digest a submission, my lord. But it was not considered when passing the award. This is a clear and unequivocal admission by the petitioner that the finding in paragraph 33 of the award is perverse and therefore required to be set aside.
Yes.
Further, the respondent had claimed a sum of rupees 25.79 crores from the claimant while issuing a letter of termination on 31st of October 2011, but did not claim the same or initiate recovery proceedings against the claimant while issuing the letter on 12th of April 2012. Then the 12th of April 2012 letter, they said, I am issuing this letter in accordance with the termination letter. And in termination letter, it is stated in paragraph 12 of his letter, termination is forthwith, number 1, and I am claiming 25.79 crores from you. Now, while issuing this letter on 12th of April 2000, it is absolutely silent. Where this money has gone, we know. This claim was bogus. This demand was bogus. They were just harassing the claimant by raising speculative, malafide claims.
No, they have admitted to deliver vacant possession in terms of the order of termination, letter of termination, where they claim 25 crores like that. But the learned arbitrator has issued the interim order in terms of your prayer at
not in terms of my prayer. My prayer is not there at all, my lord. It was their prayer that I will deliver the position on 14th.
Not their prayer. The order was passed in the interim award was passed in terms of your prayer at B.
Yes.
That is the case.
Yes. So what I wanted to say, my lord, what is B? B was that they agreed to deliver me the vacant cast peaceful possession of the premises.
In other conditions like that, there is no such.
Yes. R2 has stated that they have cancelled all the sub-licenses and asked them to vacate the premises by 31st of March 2012. But instead of vacating the premises, they remained in wrongful and illegal occupation of the premises with full knowledge of the respondent too. This is stated in 72nd sitting held on 18th of November 2015, my lord. Yes. Page 1617. 1617.
Yes.
Now here it is stated, my lord, that they remain in wrongful and illegal occupation of the premises with full knowledge of the respondent. With the respondent.
Yes.
Now, my lord, R2 has also filed a section 34 application which has been heard. In their application, he has stated respondent number 1, that is me, made no attempt to evict the sub-licensees at least till the passing of the impugned arbitral award in May 2016. So he is admitting that the sub-licensees were in occupation of the premises on the day when the award was published. Right after the fact.
Yes.
So even on the date when this application was filed, the occupants were in full possession of the premises. Of course, I will not come to that extent. I will say that at least the award was published on 19th of May 2016, and when they could not deliver me the possession, they were in occupation of the premises, I should have been awarded license fee up to the date of publication of the award at least. Mr. Mukherjee has submitted vociferously that Mr. Surana has not been able to substantiate that he has suffered damages. In paragraph 73, 74, 75, the learned arbitrators awarded me 50 rupees per square feet instead of 1950. Had they vacated the premises on 14th of April, I would have earned 50 rupees per square feet, my lord. Whereas arbitrator has given me only 19.50. That is the agreed rate in the agreement. And when it is an agreed rate is stated in the agreement, what am I to substantiate? What I am to establish? Now, considering all these factors into consideration, my lord, I have come to the conclusion that the letter issued by respondent number 2 on 12th of April 2012 was an act of fraud. Mr. Mukherjee, while making a reply yesterday, he did not elaborate anything. Mr. Surana will deal it in his application. He has raised this point of 12th of April 2014 in his application. And when I say that this letter issued by you on 12th of April 2014 is nothing but an act of fraud, so why it should not be dealt in his application as well? He says, I have delivered the position. I say, I have not received the position. He says, I will offer you the position. He knew it very well that he will not be able to perform the actions. He was thoroughly aware that he will not be able to deliver me the position. And when he was aware that he will not be able to deliver me the position, what is the fun in issuing such letters, my lord? Section 17 of Contract Acts, absolutely clear. Mr. Mukherjee also failed to satisfy the Honorable Court about that agreement which was executed by him in respect of R4. Mr. Surana will deal in his application. Why should I deal in my application? You have issued an agreement. You have executed an agreement with one of your sister concerns. Hidden from the, suppressed from the arbitral tribunal. And then before the arbitral tribunal, R4 says to delist my name, to remove my name from the array of respondents when he was in physical possession doing business there.
It is the finding of the arbitral.
Yes, absolutely, my lord.
That any one of the or all.
Yes. Even if it is the court also on 21st of March 2012, when Justice Sanjeev Banerjee has passed an order, is very categorically stated. It is applicable to one and all. Everybody is liable. Against that, they went to division bench. They did not succeed. Against that, they went to Supreme Court. They lost their SLP also there. Then again, they are saying that, no, I am not. Now, next my point is, I will establish that R2 is the successor of R1. Now, if R2 is the successor for R1, how can he run away from the liabilities? I have produced those cash memos and TDS certificates. These are there in the...
No, these are the matter of section 9.
No. My lord, matter section 9. But then what I wanted to submit, I just want to establish that they were in possession. They are still in possession.
Yes, already matters are there regarding their possession of the... So issue is that you just take a note. Issue is that you are arguing otherwise. No one is denying that some persons are there running business. The petitioner saying that is the...
I am so grateful to your lordship, my lord. If your lordship...
The arbitral award is also very clear. There are some persons, they are saying, arbitral award saying that they have some internal arrangement with you. That's why your delivery of possession is deemed, Mr. Mukherjee.
My
possession deemed. the arbitral award is not specifically correct,
No,
clear regarding the transfer of possession.
No, my lord, my humble submission is, if learned arbitrators come to the conclusion or have a finding.
No, it is not finding, clear finding is not there regarding the possession. There is no such clear finding regarding delivery of vacant possession. There is no such clear finding.
37 very categorically says that they failed to deliver the position.
Yes.
In fact, my lord, let me
But
once again.
Also arbitral award said that some bank personnel are there, some interest you have received from the bank personnel. That is the findings are there.
I would be grateful to your lordship. Kindly call the chairman of Union Bank of India. They are my bankers. Let him give an evidence that whether he has received any money or not.
It is not the place to call there or like that. I have to go through the arbitral award on. Whether it is justified or not regarding the delivery.
Your lordship will remember.
Finding of possession.
Your lordship will remember when Mr. Mukherjee was making a submission that Mr. Surana is receiving money, his banker is receiving money, and then he has come here to make himself double rich, right? Then I intervened. I said, you please produce the evidence that I am receiving money. You produce the evidence that the bank is receiving money. He failed to produce any document. He failed to produce any evidence. This is absolutely a concocted story, my lord.
Yes. No, that matter have concluded on the earlier matter. I understand the submissions of both the parties in the earlier submissions.
Here, my lord,
here
award is the same. Award is the same.
Award is the same. I have to deal with according to your objections in this matter. I will deal with their objections in their matter.
Yeah.
And
so
your
here also, my lord, in paragraph 39, kindly come to paragraph 39 of the award, my lord.
Yes.
It starts from, my lord, page 80. Other significant aspect of the matters in the issue of possession arose from the fact that disputes between the parties were overtaken, as it were, by other events adding altogether a different dimension to the issue. Now, here, my lord, my humble submission to your lordship is, an arbitrator is a creature of agreement. If something contrary to the agreement or outside purview of the agreement is happening, he is least bothered. He cannot do anything about that. Since rather he is not permitted to do anything like beyond that. Since various established business houses in the said premises as aforesaid to have induced by the respondents in terms of their supplemental agreement with the claimant were reluctant to abandon their business and vacate the premises, this resulted in great commotion in the locality, which spiraled beyond the confines of the dispute between the parties. This was the subject matter of various meetings involving political leaders, bankers of the claimant, labor commissioner, subdivisional officer, Kharagpur, shop owners, and representatives of the staff. Involvement of all these parties were well documented. Milord, there is only one letter of SDO that I am calling a meeting. And there is only one letter issued by the bank that you deposit the money with me. There's no other document on arbitral record what has happened in the meeting. Nowhere. Whatever his counsel has submitted, it has been printed. हिंदी में कहते हैं तोता मैना की कहानी. Okay, proceed. So what I wanted to say is that this paragraph 39 is absolutely a parrot reading. There must be evidence, my lord. Now, my lord, they went to Supreme Court, they filed an SLP. They filed an SLP against the division bench order passed on 25th of September. The matter was heard on 11th of February 2013 by Justice Nijar and Justice Iqbal. Their landed advocate spoke for about 10 minutes. Then Justice Iqbal said, now you stop, now you hear me out. And Justice Iqbal very categorically told him, ask your client if he is prepared to deposit the up-to-date rent today in Supreme Court. I will hear you out, otherwise get out of the court. This was the language used in the Supreme Court. The justice very categorically said, Mr. Surana may not have provided the services. Mr. Surana may be a bad person. You may not be happy with Mr. Surana's services. If you are not happy, you should have vacated the premises. Mr. Surana cannot restrain you from vacating the premises. But so long you are in occupation of the premises, you have to pay rent come what may. That was the language of Justice Iqbal, Milord. And here, Milord, they are in occupation. Mr. Midora says, I am not in occupation. Future Retail is in occupation. And then he says, I am the successor of Future Retail. I am not liable to make payment. Yes. So this 39 million, what I wanted to say is absolutely concocted story. There is no evidence. And in fact, this 35 lakh which was given by Future Value Retail Limited, the learned arbitrator said it was issued by the association. I have produced before your lordship the original letter of Future Value Retail Limited that they have forwarded this. 11 months rent. 11-month rent will become around 3 crores and 35 lakhs was only sent. My payment is per month. He has sent after 1.5 years. So what I wanted to humbly submit before your lordship, that as far as all these things are concerned, stated in paragraph 36 and 39 and 33 also, there is no evidence, there is no document on record which could establish that possession was delivered, which could establish that I received money from the occupants, which could establish that my bank received any money from the occupants. And I submit that as on date of publication of the award, I did not receive a single pie from any of the occupants. I further submit that even today, I have not received a single pie from any of the occupants. Even today.
And what is the amount of 35 lakh? Milord, 35 lakh? 35 lakh, Milord, this letter is there. Can I produce this letter? I'll just produce. Paid to the Union Bank? The bankers of the claimant?
Just place it. This is letter before it. Just one. It's a document annexed by you in the. I'll just tell you the page number. I'll just tell. That's number. I'll tell the page number. Yes. Right, my lord? Now, just kindly come to paragraph, page 24 of the award, my lord. Yes. Just 15th line, my lord. As a matter of fact. Right, my lord? What is the escrow account? There is no escrow account, my lord. Now, here, the learned arbitrator writes, as a matter of fact, the said society by its letter dated 2nd of April. Now, this letter is not from society. This letter is from Future Value Retail Limited, respondent number 4. Yes. And the arbitrator records, as a matter of fact, the said society by its letter dated so and so paid to the Union Bank of India, the banker of the claimant, the Standard Branch, Calcutta, a sum of 35 lakh to its escrow account. There is no escrow account, my lord. This money was sent to the bank. Yes, escrow account number was there. Account number is there. It is not an escrow. It is my account number, my lord. If this money is deposited in my account, my loan will be reduced. Yes, it is your account. My account, my lord. No, escrow account is open, my lord, when the SPV is issued. When there are some new proposal is there, one will deposit, he will deposit, the money will be kept in the escrow account, and then on the realization of that particular scheme, the money would be distributed or refunded. So that is a security. This is not a security. This money has come to my account. My loan has been reduced. Now, arbitrator states that money was sent by the society. It was not society. It was R4. And the money was kept in escrow account. There is no escrow account, my lord. Now, when this document was before the learned arbitrator, such finding, recording in the award is very painful, my lord. Yes.
Your Lordship, we believe we do not have a copy of this document, so kindly whatever documents, Mr. Sadhana.
It was the copy of this proceeding, I think.
Mr. Sadhana has not indicated the documents he is placing. So kindly at least let him indicate to us what documents
I
he's
just told
relying
you, I'll give you that number. Just wait, please. The file is with the lordship. I said I'll give you the number.
Have indicated
Okay,
before, so
okay,
that
okay,
we
okay,
know
okay. So show him the document. Show her the document. This is the letter dated. It was mentioned in the award. That's why he has.
This is there in volume 10, page number 1370. If you want to take a photo, you can take a photo. I will not file any document which is not relevant. I will not file any document which is disputed.
Just
Yes. This is the letter dated 2nd April 2013.
Yes.
As it mentioned in the award.
In the award, it is mentioned that this letter has been issued by the society. This letter was not issued by the society. Award says that it has gone to the escrow account. There is no escrow account. It has gone to my account only. So my humble submission is, when the finding is recorded, when the finding has been arrived at least there must be a document, and document must be properly recorded in the finding, my lord.
Now, how your banker allowed them to deposit the amount without your consent?
No, my banker has not received any money, my lord. Only from future group of companies, 35 lakh. Then again, they have sent some few lakhs of rupees. Again, company has only sent. No other occupant has sent even a single pi, my lord. I am prepared to.
This letter is by future.
Yes.
This letter is by future, copy to the organization and the bank.
Further also, my lord, up to the date of publication of the award, none of the occupants have paid even a single pi to my bank. None of the occupants have paid even a single pi to my bank or to me. I'm prepared to swear an affidavit before your lordship.
Only this amount was received by your bank.
This was, and maybe some more amount
from the future.
From future only. Nothing else.
Not from any other organization.
Nothing, not even a single pi, my lord. I would be grateful, my lord, if Union Bank could be summoned. They can give an evidence. They have whether they have received any money or not.
You are admitting that that money was received.
Yes. Whatever money the bank has received from future group has been credited to my account, and thereby my loan account has been reduced.
Yes.
Okay. And when I made my application under section 9,
there is an arrangement that the future shall directly pay the banker the money.
My lord, my agreement says that if I direct you, you can make the payment to my bankers. So earlier also, even before termination of the agreement, they have made certain payments to the bank.
Directly to the bank.
Direct to the bank. My lord, when they are making payment directly to your bank, it is their duty to at least keep me informed. No information at all. This copy, which was issued to the bank, no copy was given to me. This has been disclosed by their witness during the cross-examination. It is in their affidavit of evidence.
Okay, very well. Till today.
So, 27th years. Have you not put anything? If there be anything else,
indicate before the submitting the
Anati?
record.
698. Notice that Friday.
Next Friday 28. Next Friday 28. My humble request is, when this matter is being heard, the other record of 698 may also kindly be summoned, so that these are there.
Okay. Call me directly. Argument on behalf of the petitioner heard in part. Let the matter appear in the list on 28th of February 2025 at 2 p.m. as special fixed matter.
So as far as possession is concerned, my lord, I feel I have been able to satisfy your lordship that possession was not handed over. Possession remained with them.
Okay.
Any other document your lordship would require about possession?
Next day you proceed to the other points.